Morgen.
Good
Herzlich
morning.
willkommen zur 9.
A warm
Internationalen
welcome to the 9th
Urheberrechtskonferenz
Copyright
in der Akademie der
Conference
Künste
here
am
at
Pariser
the
Platz.
Academy of Arts,
Mein Name ist
Akademie
Katharina
der
Uppenbrink.
Künste am
Ich bin
Pariser
Geschäftsführerin
Platz.
der
My name is
Initiative
Katharina
Urheberrecht,
Uppenbrink. I'm the
die über
managing
ihre
director of the
42
Initiative
Organisationen
Urheberrecht,
140.000
and
Urheberinnen und
we
Künstler
represent
umfasst.
42
Auch in ihrem
organizations
Namen
and
herzlich
round about
willkommen in
140
diesem
authors and
wunderbaren Raum
artists.
bei
And on
Sonnenlicht
behalf of all of them,
am
I would like
Pariser
to
Platz.
welcome you
Das letzte Jahr
to
war
this
das Jahr
sunny
oder die
conference hall here at
Konferenz
Akademie der
Corona
Künste on
1.0, wie wir sie
Pariser
genannt haben.
Platz.
Dieses
Last
Jahr
year,
Corona
we welcomed
2.0
you
werden wir
to
wirklich
the
wirksam
Corona
am
1.0
Alten Ort in der
edition.
Akademie der Künste im Plenar sein.
And now we'd
In
like to welcome you back
Anwesenheit
to the
der
Corona
oder jedenfalls
2.0
einiger
edition.
Referentinnen. Und wir
So we're
freuen uns
back
sehr,
in
dass
the
wir
familiar
damit dann
place,
auch ein
at
bisschen
least
mehr
with a few
Lebendigkeit
speakers,
als
and
nur
we
die
really hope that
Briefmarkenkacheln
this will be a
der
more
Zoom-Konferenzen
lively
Ihnen zeigen
event
kann.
than the Zoom event we were holding last year.
Wir versprechen Ihnen
What we
ein
can
spannendes Programm.
promise is a very
Sie als
exciting program
Verzeihung,
and
ich bin
agenda.
kein Profi, bin aber
I'm not
gerne
a professional
meinen Job
facilitator,
eben als
but
Moderatorin
I'm
von
happy to
politischen
be
Gesprächen zu machen und übe jetzt eben auch den
facilitating
öffentlichen
today, and
Auftritt.
I
Verzeihung.
do
So,
also
weiter geht's.
facilitate
Die
political
Zuschauerinnen
talks.
können sich gerne auch
So
beteiligen über den Hashtag,
the
der eingeblendet
audience
ist,
can
und
also
indem Sie
participate
an
using the hashtag that you can
info@urheber.info
see
und
here, or
eine
by sending
Frage
your
stellen.
questions
Bitte
to
schreiben Sie sie gleich ins Betreff, dann können die
info.urheber.info.
Kolleginnen und Kollegen
Please ask
sie
your
besser
questions
erfassen
right away
und
in
an
the
uns
subject
weitergeben.
line, because then
Matthias Hornschuh, Komponist
our
und
assistants can check them
Anthemersprecher der
regularly and
Kreativen,
will later
wird
on
zusammen
here.
mit
Matthias
Musik von
Hornschuh,
5,
who is a
und er wird
composer
Ihnen
and
das
acting
Programm in Kürze
spokesperson for
vorstellen.
the creatives in the
Vorab
IU,
aber
will
wird eine
guide you
unserer
through the
wichtigsten
day together
und
with me and will
tiefsten
present the program
Mitstreiterinnen
in a
begrüßen.
second. But
Sie ist auch die
before
Hausherrin.
he starts,
Willkommen, Dr.
the
Janine Meerapfel,
host would like
Filmemacherin
to
und Präsidentin der
welcome you.
ADK.
We
Als
have
Einspieler. Los geht's.
Professor Janine Meerapfel, President of the Akademie der Künste. Dear attendees and absentees, unfortunately, I cannot be here in person today at the Akademie der Künste. I'm in Argentina, where my new film, Eine Frau, has been invited to the Mar del Plata International Film Festival. I would therefore like to send you my warmest greetings and welcome. As always, we are very happy about the joint commitment, and especially about the fact that after a year's break due to the COVID crisis, the Initiative Urheberrecht is back with us at the Akademie der Künste. And we are especially grateful for Professor Gerhard Pfennig's tireless commitment over the many years together with the organizations of the Initiative, the managing director Katharina Uppenbrink, and the many other allies. And we look forward to the exchange with Matthias Hornschuh, the new spokesperson for the initiative's creatives. The Akademie der Künste, and above all its approximately 400 members, rely and depend on adequate remuneration for their artistic activities. Actually, this should be a matter of course. If someone works and makes a contribution to society, this should be rewarded accordingly. And if I take my neighbor's property without asking, that's actually called theft. Actually, but currently there are still different standards in the online and offline world, despite some recent successes. We live in a time when we really can only shake our heads at Mark Zuckerberg's vision of a metaverse, for example, the metaverse, a kind of digital parallel world into which people can connect with their PCs, smartphones, or virtual reality goggles, a network of virtual city-states with their own rules and virtual codes. What codes? What rules? At the beginning of the internet, there was the dream of free worldwide communication accessible to all via digital networks. It didn't take
übernahm die
long,
Regie
however, and commercial
nach eigenen
companies took
Regeln.
over the reins according to their own
Nun ist es
rules.
an der Zeit,
Now it's
angemessene
time to find
demokratische Regeln
appropriate
für das
democratic
gegenwärtige
rules
Internet zu
for
finden. Die
today's
Flucht in noch
internet.
fernere digitale Welten ist nichts anderes als die
Fleeing
Flucht vor der
into
Verantwortung.
even more distant
Wir
digital
aber
worlds
sind
is
hier,
nothing
uns für die
else
Gegenwart und
than
Gestaltung einer fairen und gerechten
fleeing really
Zukunft
from
einzusetzen.
responsibility. But we are
Das
here
ist
to
nicht
work
einfach.
for the
Viele
present
Details müssen
and to
mühsam
shape a
im
fair and
Verhandeln
just
auch
future. This is not
divergierenden
easy. Many
Interessen
details have to
gemeinsam
be
erarbeitet werden.
negotiated painstakingly,
Zur
even
heutigen
between
Konferenz
divergent
sind viele
interests.
interessante Gäste geladen.
Many interesting
Wieder bildet die
guests have
Konferenz
been
der Initiative
invited to
Urheberrecht
today's conference.
das ganze
And once again,
Spektrum
the
der
conference of the
kreativen
Initiative
SchöpferInnen
Urheberrecht
ab, von der Musik
represents the
über
entire
die
spectrum
Kunst
of creative
hin zur
minds,
Literatur,
from music,
dem
art
Journalismus,
to
Film
literature,
Fernsehen.
journalism,
Es kommen auch
film,
wieder
and television.
internationale Gäste in die
And
Akademie der Künste,
once again, we
die
have
europäische
international guests
Perspektive
here
auf
at
das
the Akademie
Urheberrecht
der
und
Künste
vor
to shed
allem
light
auch
on the
die
European
Entwicklung der
perspective on copyright
Plattformverantwortung
and
zu
above
beleuchten.
all on the development of
Ich bin
platform
gespannt auf die Ergebnisse
responsibility.
der Konferenz,
I'm
auf
looking
das,
forward to the
was
results
wir
of
im
the conference,
Maschinenraum des
to what we
Urheberrechts
can learn
erfahren
in
können
the
über die Folgen, die
machine
sich nach
room
der
of
Verabschiedung des
copyright,
Gesetzespakets
about the
zum neuen
consequences that will
Urheberrecht in
emerge
der
in
Praxis
practice
abzeichnen.
after the adoption of the
Ich hoffe
legislative
sehr,
package on the
dass die
new
Politik,
copyright law. And I very much
insbesondere die
hope
Mitglieder des
that the
neuen
politicians,
Bundestags,
especially the
gut
members of
zuhören,
the
was
new Bundestag, the
UrheberInnen
German
und
parliament, will listen
KünstlerInnen
well to
fordern.
what authors and artists
Wie man
are
mir sagte,
demanding.
wird der Livestream auch
I've
noch
been
nach
told
der Konferenz
that the
auf
live stream
abrufbar
will
sein.
still
Wir
be
heißen Sie
available
also
after the
alle
conference.
gerne
So
auch
we
nach der heutigen
also welcome
Konferenz
you virtually
virtuell in der
to
Akademie der
the
Künste
Akademie der
am Pariser
Künste
Platz
at
willkommen.
Pariser Platz,
Aber
even
kommen
after the
Sie
conference.
auch mal
But
persönlich vorbei.
please also come
Vielen
and
Dank.
visit us in person as well. Thank you.
Vielen Dank, Janine Meerapfel, für den
Thank
wunderbaren
you
Beitrag
very
und,
much,
die
Professor
langjährige
Janine
Zusammenarbeit.
Meerapfel, for the wonderful
Ihnen persönlich viel
contribution
Erfolg
and also
beim
the many
Festival.
years of cooperation, and good
Ich
luck
möchte jetzt
at
als
the
nächstes
film
eine
festival.
Vertreterin eines
So
weiteren sehr treuen
next,
Partners
we're
begrüßen.
looking forward to a representative of another very loyal, consistent partner. And instead of a recorded video, as last year, we can welcome Dr. Alice Halsdorfer, Head of Department in the Senate Chancellery, Berlin, in person today.
Sehr geehrte Frau Professor Meerapfel,
Professor
sehr Frau
Meerapfel,
sehr geehrte Damen
Ms.
und Herren,
Uppenbrink, ladies
ich
and
freue
gentlemen.
mich, Sie zur diesjährigen
I'm very pleased to
Urheberrechtskonferenz begrüßen
be
zu dürfen.
welcoming you to this year's
Gleichzeitig
copyright
übermittle ich
conference.
Ihnen
And at the
herzliche
same
Grüße
time,
des Chefs der
I'm
Senatskanzlei,
conveying the
Christian
warmest
Gebler,
wishes of
der
Christian
bedauert, dass
Gebler,
heute
head of
nicht
the
hier
Senate
sein kann.
Chancellery,
Es
who
ist
is very
erfreulich,
sorry that he
dass
can't
die
be here
Veranstaltung
today.
auch in diesem Jahr wieder
It's
stattfindet.
great that you
Corona-bedingt
are
können wir zwar leider nicht in
holding this
Präsenz
conference again
zusammenkommen,
this year.
doch
Unfortunately, we
zumindest im
cannot
hybriden
all be
Format.
here because of
Dass
the
wir den
COVID
intensiven
crisis,
Austausch
but at
innerhalb der
least
Initiative
we've managed to
Urheberrecht
organize the hybrid
mit ihren vielen
conference
Mitgliedern
to look
fortsetzen.
at
Erscheint mir
the
gerade
latest
in
events that
dieser
are taking
schwierigen Zeit
place in the
besonders
area of the copyright, and that you
Denn
are
die
continuing
Pandemie
this
hat
series
in
of
der
conference is
Kreativbranche
very
zu
important,
deutlichen
especially now because
Umsatzeinbrüchen
the
geführt.
pandemic has
Und die
led to
oftmals
a
fragile
dramatic
berufliche
slump in
und
income for
soziale
many creative
Situation
minds,
vieler
and the
professioneller
precarious
Kulturschaffender verschärft.
professional situation
Insofern
of
müssen wir auch
many
weiterhin
people working in
prüfen,
the cultural
welche
sector
Handlungsmöglichkeiten
has been
bestehen,
further
um von
exacerbated. So
staatlicher
we
Seite
have
aus
to
Hilfestellung zu bieten.
check the different possibilities
Unabhängig von
we
der
have to
Pandemie
offer
erleben wir gerade im Land
help
Berlin
on
und
behalf
auch
of
im
the
Bund
authorities.
ein aufregende
In
Zeiten.
Berlin
Es
and
werden
also at
jeweils
federal level, we're looking at very
Koalitionsverträge
exciting
verhandelt,
times. A
neue
coalition
Regierungen
agreement
gebildet
is being
und
negotiated, new
insofern auch
governments are
neue
being formed.
medienpolitische Schwerpunkte
So
festgelegt.
I think we can also say
Eines
that
ist
a,
sicher,
a new focus
Berlin
is
wird
being
auch
developed on
künftig
media
ein
policy or in
international
media
beachteter
policy. So
Standort
Berlin will
in der
continue to be
Medienlandschaft
an
sein
international
und Talente
renowned
aus der
location
ganzen
in
Welt
the
anziehen.
media landscape
Im
and
Jahr
attract talents from all
2019
over the world. In 2019, there were more than 37,000 companies in Berlin being active in the creative economy, with around about 160 employees and a turnover of 25 billion euro. And Berlin will remain the most important film location in Germany. However, the framework conditions have to be right. We need a fair environment, fair market conditions, and a balanced copyright, which represents the current challenges resulting, amongst others, from digitalization and new technologies. Much has changed here. The European Union has launched the biggest reform of the copyright legislation in the past 20 years, and now the German legislator had to transpose the directive into national law. That happened this year. In the Copyright Act, the Copyright Service Provider Act, and the Act CITES. These provisions and regulations cover several topics: ancillary copyrights, press publishers, text and data mining, and parody, for instance. And we'll be hearing first assessments from the practical world, from people affected, the associations from Brussels, collecting societies, but also from German politicians. There is the upload directive, which aims at avoiding a violation of copyright with automated mechanisms, but at the same time does not want to restrict freedoms too much. We have YouTube, Instagram, TikTok, and these platforms are being regulated under the new Copyright Service Provider Act. So we're all excited to find out whether the debates have been worthwhile, sometimes fierce debates. Berlin thinks it was right to adapt the regulations in a comprehensive way to the latest developments in the media landscape. It is especially the fast developments of the platforms that required a modification and amendment of current legislation. However, the future will show whether we've managed to achieve that goal of a fair balance between creative minds, companies of the cultural landscapes, platforms and users, or whether we have to do corrections of the legislation. And in that respect, we are looking forward to your experience and your assessment. As the federal stand of Berlin, we also deal with regulating platforms in other levels. So the media, interstate media treaties are being negotiated at a federal state level and not at federal level. And they aim at guaranteeing diversity. Amongst others, this is to be done with a ban on discrimination for the big tech firms such as Google, etc., and that will have a positive impact on our media landscape. The federal state of Berlin will actively provide guidance in this area, and will have a close look at the impact this will have on all affected stakeholders. We will cooperate closely with the creative industry to also, in a timely manner, adapt the regulations accordingly. And we will look at the coalition negotiations very closely to be able to be actively involved in the next legislative term. I'm looking forward to the expert presentations now and wish all of us a very exciting and fruitful conference. Thank you very much, Dr. Alice Halsdorfer. We're also looking forward to cooperating with you in the future. What a strange time, ladies and gentlemen. We are in the autumn time after the implementation of the European Copyright Directive, which, it must be remembered from time to time, is a directive for the digital single market, and not so much a cultural directive, and in this respect has a fundamental significance beyond copyright. We will take a closer look at it. At the same time, we are in a political interim period. We're looking at the formation of a new government, but we also have this nasty virus. And it actually has more to do with copyright than many suspect, not only because it is raining in our event, but also because the corona crisis has mercilessly exposed the fragility of the revenue models of those operating in the frame of copyright. So we should keep that in mind. Let's start with the defining topic of the copyright debates of the last few years, the DSM directive and its national implementation. And let's inspect the engine room of copyright. We have received a whole package of legislation, including a completely new law, the Copyright Service Providers Act, which primarily transposes Article 17 of the directive into the new law, while the copyright contract law aspects from Articles 18 to 23 are subject to the reform as a whole. The new law must now be implemented in practice, and this much can be said for sure in advance. We will not catch more than a first glimpse of this implementation today. We're all the more pleased that the practical machinists are sharing their perspective with us today. Perhaps in a year's time at the 10th Copyright Conference, when the main implementation deadlines will have expired, we'll be able to draw a first interim conclusion. The second part of our conference will look at the implementation of the EU Copyright Directive and the state of play in Europe. So our colleagues from the umbrella organizations in Brussels will inform us about the state of affairs in Europe, especially with regard to the implementation in other member states. Actually, all three wanted to come, but they're still in the course of negotiating the negotiation. And then we also have in part 3 the Digital Services Act. Regulation is continuing here in Brussels, also this time in form of 2 regulations that will be directly binding on member states. So we should have a look at the Digital Services Act and the DMA at the same time. And then we also welcome the federal government, the Federal Ministry of Economics and Technology, which also will be represented in this round. And then we have part 4, which is called After the Elections, where we come to the federal government, and even though we don't know it yet, we're going to give it a lot of work to do. Rather, it's our experts who, by all accounts, have formulated the topics of streaming, remuneration, e-lending, and associations' right to sue, and last but not least, private copying as homework. And in a year's time, we'll be asking them to take the test. So we'll start with part 1, the engine room of copyright, and we'll like to welcome Dr. Urban Papi, the first machinist, really, the managing director of the collecting society Bild Kunst.
Yes, Matthias Hornschuh, Katharina, thank you, and I'm very pleased to be with you today and open this first section. I'm well aware that time is short, so I'll start right away. In this first part, as we've heard, it's all about the challenges which are posed by implementing Article 17 of the DSM directive in Germany through the Copyright Service Provider Act. That is all upon us. And in this wider context, I would like to refer you to a very interesting, ambitious project from the wider sector of imaging. We're talking about the new social media image license, which the Collection Society Bild Kunst, together with the Federal Association EVPA, is going to introduce into Germany and also will present to the Collection Society. I've got a little diagram which comprises all the details. It is a little surprising, but you will see that this license, social media image license, will cover everything which is like photography, illustration, pictorial arts, design. And particularly exciting is that this social media image license is set up as an extended collective license. In other words, we are using the new tools provided by Section 51 following of the collection law. That gives us an opportunity to also have third parties come under this law. That means 100% of the image repertoire is offered. We are cooperating with all the important agencies in this field, and we have a whole network of collection societies abroad, so I think we are a truly representative body. The social media image license is supposed to close the legal gap that the service providers still show. In this respect, it targets particularly the image upload of private users as soon as these images aren't clear as to their copyright. What is not covered are the uploads of private works of users, like if you upload a holiday picture which you yourself took, then obviously you have the copyright and can yourself decide whether or not to provide the collection societies with the right of use. The upload of commercial users is another matter too. Commercial users will settle their rights issues in the marketplace, and they can grant platform operators these rights, in which case the platform provider will benefit from Section 6, Paragraph 2 of the Copyright Service Provider Act. But here we are using the new direct remuneration claim for all our authors according to Section 4, Paragraph 3 of the Copyright Service Provider Act. And of course, the legal claims of remuneration are also included, which are part of Section 5, Paragraph 2, i.e. if an image is used as a pastiche, a parody, or caricature. So altogether, every stakeholder will benefit. Let's look at the service providers. They get a one-stop in this very highly frequented image area. That will prove to be a huge asset. And of course, the authors and agencies themselves will receive appropriate remuneration for the exploitation of their works, which has so far been unregulated. And in this respect, let me also point out that we strive to get a share of the turnover according to Section 39 of the Collection Society Act. And last but not least, the wider public will also benefit from this new institution, because if a service provider concludes the social media license with us, then the uploads of pictures which are not legal will be a matter of, we won't have the upload filter anymore. So that's why people will benefit in the wider public. So much in all brevity, as it were. I'm quite happy to answer questions if you have them.
Ja,
Thank you.
Urban Papi, vielen Dank.
Well, Urban Papi, thank you very much indeed. We're now looking forward to the discussion and to look at how these first initial steps of implementation, which sound quite promising, will be addressed. Let me take this opportunity of to point out that a great number of the PowerPoint presentations are going to be published on our website after the conference, so you will be able to study the information in detail then. An illustration is always more than an image. An illustration is a language which crosses borders in order to tell stories, explain facts, summarize content, assess, provoke, and or reach out to the emotions. So, this is what Annika Siems says, the illustrator and chairperson of the Illustrator Association, who sadly isn't able to be with us in person, but she sent us a video clip. Thank you for that. Hello and all the best from Hamburg. I'm Annika Illes. I'm an illustrator and author and currently the chairperson of the Illustrators Association in Germany, in short IO. IO is the only organizations for people like us, and currently we have 2,300 members.
Wir vertreten Kollegen und Kolleginnen aus allen erdenklichen
We are representing colleagues from all sorts of different
Das sind weitaus
collection
mehr, als man
and
denkt, denn
exploitation
Illustration findet ihren
frameworks,
Einsatz
and
in
there
ganz
are a lot of them, because
unterschiedlichen
illustration is something which is used in all sorts of
das neben
sectors,
Editorial-
starting with the
Werbeillustration
children's book,
wahrscheinlich
apart
das
from
ist, was einem als
editorial
erstes in den
and
Sinn kommt.
illustrations
Ist Illustration
for
aber weitaus mehr
PR,
als das.
is probably the first thing
Unsere
people think of.
Aufgabenfelder
But there
erstrecken
is
sich
so
von
much more.
den
Our
entwerfenden
areas
Tätigkeiten über
cover
Erzählungen zu
design,
Illustrierenden, zum Beispiel in
narrative
Wissenschaftsillustrationen,
stories,
aber auch
scientific
über beratende,
illustrations,
moderierende oder
but
gar
we also act as
ausbildende
advisors, moderators, or even
Die
trainers.
Illustration ist dabei unsere Bildsprache,
Illustration
also unser
is our
Kommunikationsmittel,
pictorial
um auch
language,
komplexe
our means of
Sachverhalte
communication,
visualisieren
which
zu
we
können.
use to visualize
Illustratoren
contents that
sind
may be
Urheber.
very
Wir arbeiten
complex.
fast ausschließlich als
Illustrators are
Solo-Selbstständige
authors.
und unsere
We are
Existenzgrundlage
almost
basiert darauf,
invariably
dass wir Nutzungsrechte
self-employed,
einräumen
and
und Lizenzen vergeben.
the basis for our
Daher sind wir auch
existence is
darauf
to have
angewiesen, dass wirklich jede Nutzung
exploitation
vergütet
rights
wird.
and licenses that we can grant. So we
Digitalisierung
depend on
hat einen
having
großen
everything we
Einfluss
do
darauf genommen, in
remunerated.
welchen
And
Medien und
digitization has
Kontexten
had a major
Illustrationen
impact on the
verwendet und
media and
gezeigt werden.
context in which illustrations are
Dabei erkennen wir
used and
eindeutig einen
shown.
Trend zu einer
And
größeren
we see a very
Nachfrage.
clear trend. There
Diese
is
ist
more and more
vermutlich darauf
demand for
zurückzuführen, dass wir in
illustrations.
der heutigen Zeit
And that is
große
probably due to the
Informationsströme
fact that
haben
this
und der
day and
Konsument
age we have
einfach
such
mehr
huge flows
Struktur,
of information
Navigation
that
und
teachers
Fokus
need
benötigen, um
structure,
sich daran
navigation,
zurechtzufinden.
focus to find their
In
way
dieser
through all
Marktverschiebung in
this.
den digitalen Raum
Because
profitieren
of
in
this
erster Linie
tectonic shift
Uploader,
in the digital
Verwerter
space, the ones who
und
really
Plattformen,
benefit
die mit
are
Bildern eine
uploaders,
größere Sichtbarkeit und
exploiters,
Reichweite
collection
erreichen.
societies, platforms, because they
Es
have a
findet eine
far greater
Wertschöpfung in
reach
erheblichem
through
Umfang
images.
statt, an der wir
So there is a
Urheber
lot of
und Urheberinnen
exploitation
jedoch
and
bislang
collection
wenig bis gar nicht
of a
beteiligt
scope which is huge,
Wir haben
but
also
which does
folgende
not
Situation,
include the
eine größere
authors.
Nachfrage,
So
eine
the situation
geringere
is a greater
Beteiligung,
demand, but
also
there is less
folglich
participation
ein
and
Value
involvement
Gap.
for us. So there is a
Wir
value
als
gap.
Verband begrüßen daher die
As an association, we
DSM-Richtlinie und auch die
therefore welcome the
Umsetzung in
DSM
nationales
directive
Recht.
and its
Der
implementation into national law.
politische Wille, die Position
The
der Urheber
political
und
will
Urheberinnen zu stärken,
to
ist ganz
strengthen
offenbar
the position
vorhanden.
of
Und
authors
im neuen Gesetz
seems
erhoffen
clearly
wir
to
uns
be
nun,
there.
dass wir
From
ein
the new
Werkzeug in
law,
die
we
Hand bekommen,
hope
das sich am
to
Ende
be
nicht als stumpfes
given a
Schwert
tool which will turn
herausstellt.
out not
Eine
to be a
gerechtere
blunt
Verteilung
sword,
auch in der
which will
Realität
see
herstellen
a
kann,
more
nicht
fair
bloß in
and
der Theorie.
equitable distribution in reality, not just.
Wir hoffen außerdem, dass sich der gestärkte Anspruch
also
auf
hope that
Auskunft
the
über Art und Umfang jeder
Reinforced
Nutzung
claim
urheberrechtlich
on
geschützter
information
Werke
about scope
positiv auf
and any
Entscheidungen zur
kind of
gerechten
use
Verteilung des Kuchens
and
auswirken.
exploitation of an
Hierbei
author's work
könnten
will
die
have a positive
Erlösströme aus den
effect.
Verwertungsgesellschaften
We need a
eine große Rolle
dialogue
spielen.
with the collection societies, and
Gleichzeitig
that
sind
will play
einige
a major
Regeln für
role.
unsere
But at the
Praxis
same
jedoch
time, there are some
problematisch.
rules for
Etwa
our practical
diejenige
work which will
mutmaßlich
prove to be a
geringfügiger
problem. For
Nutzung.
example,
Die
the
gesetzlich definierte
supposedly
Grenze von 125
smaller
Kilobyte bis
usage,
der
120
Bilduploads im
kilobyte is the
Wesentlichen
legal
freigegeben sein
border
sollen,
from
ist
which
angesichts des technischen
image
Fortschritts
material should be
unhaltbar.
released free. And
Bereits
given
heute ist es
technical
möglich,
progress, this is no longer
125
tenable.
Kilobyte
Even
große
today, 120
Vektorgrafik im
kilobyte
Browser auf 1,5
large vector
Megabyte
graphics can be
hochskaliert darzustellen.
scaled up to
Die Größe und
1.5
Auflösung der Bilder
megabytes
muss
in
aber
your
unbedingt
browser
begrenzt
and
bleiben,
portrait.
damit
But
die
we need to
Verwertung
have a
dem Urheber
limitation
überlassen
still in
bleibt.
place, because
Die
otherwise
bessere
we will have
Alternative wäre
exploitation
daher
with our
eine
copyright.
Begrenzung
So
basierend
it would
auf
be better often
Pixelbasis.
to have a pixel-based
Ein weiterer
limitation
Punkt ist das
introduced.
sogenannte Pastiche.
Another point is
In
what we call
Anlehnung an die
prestige.
bisherige Zitatschranke ist
Following
von nun an
the
die
quotation
Vervielfältigung und
barrier which has
Verbreitung
been in
unserer Werke
place
zum
so
Zweck der
far,
Karikatur,
a
der
manifold
Parodie und eben des
use of
Pastiche
our works
zulässig.
for the purpose of
Dazu, was aber ein Pastiche in
caricature
diesem
and
Zusammenhang
prestige
sein soll,
is
gibt der
necessary. But what
Gesetzgeber
exactly
keine
is
klare
supposed to be
Definition
defined as prestige is not made clear by the
Diese wird also
legislator.
voraussichtlich im ganz großzügigen
So
Maße
we
von
expect
Verwertern
that
und
prestige
Plattformen
is going to be
interpretiert werden.
interpreted in an extremely broad
Bis Gerichte
basis by the
über
collection
Auslegung und
societies and
Grenzfälle
platforms
befinden.
until there will be
dem
court rulings about how to
befinden wir Urheber und
delimit
Urheberinnen
all
uns also
this.
als
In order
Solo-Selbstständige
to
erneut
find a
in der
solution, we
Situation,
as
dass wir uns
self-employed
gegen große
illustrators
Konzerne
are
und
again in a
Unternehmen,
situation where we have
also
to fight
gegen
against
unsere
the
Verwerter,
large-scale operators, companies and
Neben Fragen der
platforms.
Verwertung ist für uns als
Apart
Urheber
from questions of
Persönlichkeitsrecht von großer
exploitation,
Bedeutung.
the right of
Sofern das
the
Pastiche verargumentiert,
individual
kann
is
mit
very
meinen Bildern ja
important, because the
theoretisch alles
prestige
gemacht
argument
werden,
means
ohne
that,
dass ich
well,
etwas
you can
dagegen
use
tun
anything
kann. Und es ist auch
and
egal, ob es mir
do
gefällt oder
anything
nicht.
with my pictures
Ich habe
without
keinen
me
großen
being able
Einfluss
to
mehr darauf, in welchem
impact it,
inhaltlichen
whether I
Kontext
like it
meine
or not.
Arbeiten
I no
gezeigt werden.
longer have any
Dass mir das
influence in which
Bauchschmerzen bereitet,
context
können Sie sich
my
vorstellen.
image work is shown. And
Wir sehen, dass
obviously
die
you can
Umsetzung der
imagine that
Richtlinie
this causes me
grundsätzlich in
quite
die
some
richtige
headache.
Richtung geht. Im
We
Detail
will
gibt es
see
allerdings
that
noch einige
what is planned
offene
for the
Fragen,
national
die aber
law goes in the
entscheidend
right
dafür sein
direction
werden,
by and
ob wir
large, but there
Urheber
are
und
still some
Urheberinnen
unresolved
letztendlich
issues,
auch
and
in
these
der
will
Praxis von der
be
Richtlinie
decisive as to whether or not we authors will end up benefiting or not from what will become the law. Thank you very much and enjoy the rest of the conference.
Danke und herzliche
Dear Annika,
Grüße
thank you very
nach
much.
Hamburg.
And very
Wir
warm
kommen jetzt zu einem der neuesten
hello to
Zugänge
Hamburg again. We're now coming
der
to
Initiative
one of the
Urheberrecht,
newest
zum Verband Pro
partners that we have, that is the
Unser aller Freude
Association
hat sich
Pro
ein
Musik.
Verband
because we're all very happy that one of the organizations of musicians has become established at the beginning of the year. Ella Rova is a cellist, a second chairperson of Pro Musik. She was going to come in person, but sadly, health-wise, it was impossible. But just at the beginning of the week, she sent us a little video clip. So let's have her brief video.
Guten Tag, mein Name ist
Hello,
Ella Roba. Ich bin
I'm
freischaffende
Ella
Cellistin
Roba.
aus Köln.
I'm a
Und heute
freelance
darf ich hier
cellist, and
sprechen
today
als zweite
I'm
Vorstandsvorsitzende
talking to
von
you in my capacity as the second chairperson of Pro Musik, which is an association for freelance musicians. I'm very happy that after we officially became an institution at the beginning of this year, we have already been received by you and accepted, and I'm particularly glad to be able to have the opportunity to say a few sentences to you from the point of view of freelance musicians. Particularly, I would like to focus on the shift, the paradigm shift, which results from the coming into force of the new package of legislation. We all know the term, the shark-infested waters of the music industry. And we make very clear that there is an imbalance of power within the music sector. Because on the one hand, we have the music authors and musicians, often they are one and the same, and they are the ones who create the musical content. They put their work, their time, their passion, everything into this artistic product and create something new. And on the other hand, there are the publishers, the labels, so-called record companies, the ones that are the collection societies. They have no share in the creative part, but they have the know-how of marketing these works, which often we musicians are lacking. So they make sure that these things are published, and they also constitute an important part of the value chain. So it would be highly desirable to have a fair symbiosis where both sides act as equal partners, and it's value given to culture, to the work of art, which should be the highest good, which everybody has in mind. At this time, with the platforms and YouTube and so on, from the point of view of music creatives, we've seen, yes, well, there was no equal distribution, but a mixed calculation which was in place made sure you could live off it. Physical sales, then fees paid by the collection societies, concert fees, and this altogether has made it possible to continue working as a creative in music and to have some basis for living, which you could earn from that. But by now the situation has changed. It was only later on that the sector realized the so-called positive, fast, immediate global availability of music contents online had an undesired side effect, namely that the physical market was shrinking. As a result, looking at it from the point of view of the music creatives, there is a question which touches on our very existence. How can I earn my money now? As Pro Musik, we are an association which represents the interests of the authors and the copyright holders. We write music, we arrange music, we play music, we are part of all sorts of projects, we do recordings for us, but also for others. That's the reality of life of many creatives in the music world. Many of us over many years have signed contracts, which in retrospect have turned out to be bad for us. Total buyouts for studio recordings, which actually exclude musicians from any further value added, and that's standard in the industry. Possibly the new change in law will have an effect, will affect a change there too. The platforms for many years have simply used our music content without any legally binding solution in place, how our copyright and other rights should be respected. In many cases, of course, we transferred all ancillary rights, but we still have a right to remuneration. And it is the direct remuneration that we have a right to. And we think this is what makes it necessary to achieve a fair change of the supply chain. The new law should make sure that our right to remuneration isn't ignored simply because it's complex or because it's cheaper not to take it into account. But the legislators recognize this, and now they have really initiated long overdue paradigm shift. So far, nobody knows how exactly to implement these new ideas into practice or into law. or
Es
how
ist ein
to
wichtiger
react.
und richtiger Schritt
But it's still an
aus
important
den
step and the right step,
Vielen
a
Dank.
way out of the shark-infested waters. Thank you very much.
Ja, danke, Ella. Und,
Thank you,
gute
Ella,
Besserung. Wir haben
and
gehört, dass deine Stimme ein
I
bisschen
hope you have a speedy recovery. We
wechseln von
heard
den
that your voice is a bit
leistungsberechtigten
scratchy.
KünstlerInnen, die hier mehrheitlich jetzt
Let's
gerade
go away
vertreten waren,
from
zu den
the
urheberrechtlich
artists
geschützten musikalischen Werken.
who
begrüßen
are
Dr. Götz
copyright
von
music
Einem,
protected.
Director
Now
GSA
let's welcome
Peer
Dr.
Music
Götz von
Germany und
Einem,
seit
Managing
ein paar
Director of
Tagen
GSA
Präsident des Deutschen
Peer Music
Musikbundeserverbandes
Germany. For some
Herzlichen
days
Glückwunsch,
now, he's been the
Götz.
president of the German
herzlichen
Music
Glückwunsch.
Publishers Association. Congratulations and welcome.
Und guten Tag allerseits da draußen.
Thank you, and hello everybody here
Ja, ich
and
spreche hier heute
outside.
tatsächlich
Right,
Präsident des
I'm
Deutschen
talking
Musikverleger
here as the president of the German
bisschen was zur Leistungsseite
Music
sagen,
Publishers
was einfach
Association,
daran
and I would
ist,
like to say something about the ancillary rights in particular. That's partly due to the fact that we are often representing authors who are both practicing artists, and it's their interests that we need to bear in mind. Let's start with the positive things, since we've been talking about the engine room of copyright law. The positive news is that we have a responsibility. We finally made clear what the platform responsibility is. We always thought they had a responsibility, but finally the legislator has cast it into stone for the content that is uploaded by the users to platforms. I think the positive news also for the platforms is that they're showing a way how to do it, how to license content. Not that nobody had any idea how to do that in the past, but they've now done it. I think the good news, particularly in the field of music, is that 20 years ago the best efforts have been required. And in the field of music, these are very simple ones, we think. There's already a legal context between the collection societies, the labels, and the platforms. So the license partners, both are for existing platforms and for new services, are known. And even better than this, it's also well known just what kind of remuneration is expected. For example, we have the rates of the collection societies where you can actually see what is being paid. So we hope there's going to be a practical impact, and we hope that this will be reflected in the license agreements being negotiated. One has to say that the discussion about copyright all started with a value gap, and that's really what makes a difference between what we get paid by streaming services, Spotify, Apple, and so on, and user-generated platforms on the other, user-generated content platforms on the other end. One has to be honest, it also should be considered what the situation with data is, because that would be another area where we should cooperate, so we have as much use-based pay as possible. Let me also add that music, even in the political debate, has always been a sector which says we want licensing, not blockaging. We were the first sector to be impacted by the digital revolution, and we were the first to find a way out. And today, I can say 100% of the rights repertoire is made available online. Now, the counterpart to this comprehensive licensing, we have always thought, is the opportunity which needs to exist to have an effective situation where authors, artists have the opportunity to say, when it comes to their individual rights, it is my decision as to whether this user may use my music for this or that purpose, yes or no. That's why the upload filter discussion, and I don't want to go into detail about that, is not so relevant for our particular area. Because, as we see, there is no such thing as a basic right for the free use of any available content. I think politics are dealing with a very complex construct of rules and exceptions. That was the political reaction, the allegedly permissible use and so on, or assumed use, permission. Well, there were all such things like minor use, petty causes. And I think the first reactions from the practical field is that politically that was just the wrong signal to be sent out. The first people now are coming saying, well, I've got free use for 15 seconds. I don't need anybody's permission if I use 15 seconds of a piece. And then you have to go and explain, no, this is not how it works. That's not how it was intended. That's not what the law says. There are lots of other requirements to be fulfilled first. So right, we have a signal here which, from our point of view, contradicts the idea of the cause because it actually questions the right of the author about his or her creation. Nobody would allow my neighbor to put his sort of lounger into my garden. I don't have to accept that. Why do they have to accept it from me? So from our point of view, the whole thing is also supported when we're looking at the various barriers. That was one of the demands all over Europe. It's quite a good thing that at least we have the direct remuneration claim to compensate, but the scope is not clear. And if, as the legislator, you write that samples are, as a matter of course, to fall under the same provision, then that is the wrong sort of message, because samples have never been free of charge. You always needed permission to use a sample, and I think every producer knew that if I move that sample or snippet of a sample from here to there, there's a liability consideration, and that is something which we no longer have now.
Letzte Wort möchte ich vielleicht eine Sache noch zu dem Direktvergütungsanspruch.
And as a last word, I wanted to say something about this claim to have direct remuneration, which the previous speaker also mentioned. As music authors, who we represent, but also as the publishing houses, it's maybe not quite so relevant, because, as I say, we have the collection societies, which are responsible for exploitation of rights. And we've always said we do completely understand the direction in which you're going, because there is a group of creatives that really does need to be protected. Our fear was always that this direct remuneration is too much of a generalizing approach, and we will see more about that, and I'm sure we'll hear more about it today. I think the big hurdle on this particular issue is going to be how to put that into practice, and we fear that it'll end up with giving us less than we thought. At least it doesn't make licensing any more transparent. That certainly is so. I mean, when I come to the end now, as the music sector, it's now up to us to deal with the new regulations and see how we work with them in practice. So we can't tell you much about that yet, even though I'm sure there will be some questions which will have to be referred to the courts. And that always is an indication that the legislature just hasn't done its job properly. Thank you.
Thank you very much, Götz von Einem from the German Music Publishers Association. Earlier this month, you said something very important, namely that finally we will work to ensure that the authors we represent can live off the proceeds of streaming services. This is, of course, a quote that we've chiseled in stone, in a stone of gold in our headquarters at the Initiative Urheberrecht. Maybe you could pass on to the next speaker, Katharina. Yes, our next guest is Dr. Georg Nolte, Senior Legal Counsel from Google Germany. And you have the floor. Thank you. Ms. Oppenbrink, Mr. First Soccer in only 5 minutes, but I will try to at least present a few first conclusions from practice from YouTube's point of view. The regulations of the Copyright Services Provider Act can be split up into 3 pillars. Firstly, the best effort commitments of the platforms, that is the obligation to avoid violations to the copyright and the obligation to legalize uploaded content through licenses. Then there is an additional pillar, which is the regulations on the interests of the users, protecting the interests to avoid over-blocking mainly, and then the statutory claims to remuneration. On the first pillar, I think it's useless to discuss whether Section 17 has increased the liability vis-à-vis the previous regulations, because even back then, platforms at the same degree of liability, the court in Munich is so as a matter of fact, and the German court ruled rather strictly. The European Court of Justice this summer decided that YouTube has taken appropriate measures in order to fight against violations of copyright in an efficient way. And Content ID is the best system worldwide to avoid violations to the copyright. So in the implementation of Section 17, YouTube has also introduced the copyright matching tool in order to further avoid additional violations. With regard to compulsory licensing, the German legislator calls this a duty to license, which is referred to a considerable repertoire and a high volume of upload. It remains to be discussed where the thresholds and limits are, and I'm pretty sure that will lead to intensive discussions in the future. But there's one thing which is clear: the Section 17 alone has not increased the cake of overall income of the platforms. So we still need to discuss how to share this cake, and that YouTube is licensing content is nothing new either. In the music sector alone, we have paid more than $4 billion to the right holders. Now, on the second pillar, while in Brussels, it's mainly the rights of the right holders and the interests of the right holders that policymakers focused on. In Berlin, it's rather the interests of the users. User flagging and de minimis or minor regulations are something that Berlin focuses on, and this has been described as something truly tricky, and Section 17 is not an exemplary case of legislation. It contains many contradictions and is extremely complex. And the same can be said about its transposition into national law. I'll give you an example. There is a complaint procedure where the platforms have to organize a hearing within a very short period of time, and then have to take a decision on very complex matters of copyright and ancillary rights and exceptions. However, we think that the German legislature has found an appropriate solution, which can also serve as a blueprint for other member states. Therefore, we did not only implement the Copyright Service Provider Act nationally, but globally, because that's the only way this makes sense to us. And experience has shown that this works quite well. Altogether, there are not very many complaints and grievances taking place. It seems that most of the users of the platform can live with it. Now, on the statutory claims to remuneration, they are something that we find very problematic. This seems to be a national special route, so to speak. No other member state has introduced similar regulations. I think they're well meant. However, they are very, very complex. And at the end of the day, I don't see that they will lead to more fairness in distribution. This area, and I think first talks with collecting society show that very clearly, is rather unclear. We don't know what a pastiche really is, how much pastiche is being uploaded on YouTube. We don't know that, and we won't know that in the next years either. What kind of remuneration ought to be paid here, and how can we make sure that this remuneration is paid to the right holders? So that leads to difficult distribution questions, not only here, but also in direct remuneration, which should not lead to an exclusive online remuneration on additional load for platforms. And here the same questions arise. Is this appropriate, and will this lead to more money for the right holders in the end? So it's very early to really take stock here and make an evaluation, but I think it will also take quite a few more years until we get a real evaluation of the situation. In a nutshell, I think we can say the German legislator has created a good model. The interests of the users and the right holders are being balanced. However, at the same time, the transposition into national law also helps to maintain the general openness of the platforms, and that's something we should not lose sight of when discussing the details, especially the money in the next years. Thank you very much, Dr. Georg Nolte. I'm pretty sure we will come back to some of the aspects you mentioned later. Now, to close this part one, we would like to ask GEMA's General Counsel to address some of the aspects that have already been mentioned and addressed here. And I'm pretty sure you will also raise more questions. Well, yes, thank you very much. I'm not going to disappoint you. I'm very pleased to be invited again to the Copyright Conference and to be here in person to speak to real people. That's something I haven't had in the past, so I'm very pleased that I'm back here with you. Having a look at the engine room is difficult. The people in the engine room are scratching their heads because they don't quite understand all of the regulations and provisions. But to conclude that is a failed act is not right, I think. It's a change in paradigm. It's something that put an end to 20 years of unfairness. 20 years ago, we talked to YouTube for the first time. We concluded a first license agreement with YouTube in 2008. And then we had a litigation lasting for almost 10 years where we tried to make sure that platforms are responsible for the content that is being assessed on the platforms. And jurisdiction has always pointed to liabilities, but the question who's responsible for concluding licenses and remunerating the creatives has never been answered or not answered satisfactorily, in that the uploader is liable, but the uploader usually doesn't earn any money with the platform. It's the platform itself that makes the profit. So this change in paradigm was necessary and it took place. So I'm seeing a clear improvement vis-à-vis the old legal situation. Mr. Nolte pointed to Ziandor Elsevier and the ruling of the European Court of Justice of June this year, where we learned that a real responsibility outside of the copyright directive will not exist in the future either. So what about the implementation into German law in the Copyright Service Provider Act? This will, I think, lead to more licenses, especially in the areas where content has been tolerated so far. This is where we think a license system will evolve, and that's due to the obligation of the platforms to license or to at least negotiate licenses and conclude respective agreements, and not only to tolerate what's happening on the platforms. And also this fear of being kicked out of the platform is no longer there. It's gone, and therefore the number of licenses will grow. That refers to genres that where licenses have not been widespread. We heard about pictures, images, audiovisual arts, also texts and films. All of these things that took place on the platform but had not been expressly licensed. So now the question remains, what type of content is subject to licensing? What type of content is being reproduced at the platform only to a minor extent. I think here the German legislation is rather weak. Then there's another point, namely that the existing licenses can be renegotiated to improve conditions, which is good for the right holders and is due to the copyright contractual law and the direct remuneration claims. Now, the fear to negotiate with a much stronger partner, saying that if you really want that amount of money, we'll just take down the content, I think this threat is no longer valid under the current legislation. Of course, I'm hearing the counter-argument of the platform stating that the cake is not growing, we can only distribute the money that is there. I don't think that's a real line of argument, because, of course, the remuneration for the creators have to grow. That was the only sense, the only meaning behind that reform, to close that value gap. And to use that line of argument simply does not represent the purpose of this reform. Of course, it's obvious that there will be more blocking the more licensing we have, and I also think that the number of complaints and litigations and content that is really being blocked will be reduced in the future. And let me just point to some risks to conclude with. It's true that in the scope of the platform responsibility, the German implementation has been very ambitious to really define as many platforms as possible when it comes to responsibility. So they looked at service providers under the new law. Then there are exceptions for startups and smaller services. Then they focus on the question of content, which is only used to a minor extent. Here, we think the adjustment screws have been turned a lot to define as many exceptions as possible. Now, France has defined minor use, and they said so and so many songs are no longer minor use, and so many songs fall under the scope of the directive. So, in consequence, I think we will see different regulations, also regarding the question who is liable and who isn't, and that's certainly a matter that will be referred to the courts. Other than that, I'm very confident that things will improve. There will be many reasons to argue, but I think there are also many reasons to find good solutions. Thank you very much, Tobias Holzmüller. We also have many good reasons to switch to Part B of Part A? No, Part 1. I'm a bit confused. But the speakers will, however, be available for questions after the break at 12 o'clock. Please use the hashtag that you can also sometimes find on the screen. It's called hashtag Zukunft, and then without any space or anything, URHR, and you should also be aware of capital letters. And then also send us an email at info@urheber.info. And now we will look at the copyright contract law set out in the Digital Single Market Directive in sections 18 to 23. And in Mainz, I'm welcoming a colleague. I hope she's there. She's a disputatious colleague, so to speak, and a dear friend of mine. She's the photographer and journalist Heike Rost. She's active in the Rhineland-Palatinate Regional Executive Committee of the German Federation of Journalists, has been a member of the Press Council since 2002.
Lassen Sie mich das an zwei Praxisbeispielen der neueren Zeit erklären. Vergangene Woche erhielt ich eine Anfrage aus dem Fachbereich Architektur einer renommierten Hochschule. Im Rahmen eines Studienprojekts sollte ein Architekturführer über interessante Architektur erstellt werden. Man sei dabei auf meine Fotos eines Großprojekts gestoßen. Professionell aufgemacht soll diese studentische Arbeit in einem Verlag erscheinen. Man verfolge aber keine kommerziellen Interessen. Es folgte die Bitte, Fotos zur Verfügung zu stellen.
They said, please make your photographs available. Then there was a contract which a professor of the university had drawn up. I mean, no more rights to me. They have the right to use and change the photograph. No liability in case third-party rights would be limited. All liability remains with the photographer. Plus, another clause, no fee payable. My answer was polite but short, contract unacceptable, and I do not provide pictures free of charge. I could have said I live off marketing my pictures, or rather, I live off having exploitation rights, copyright, remuneration. My answer is typical for what photographers are saying. Not everybody is so stubborn as that professor who sent to me another letter a few days later regretting my cancellation and then asked, couldn't I make the pictures available free of charge after all? It's much more acceptable that you have some colleagues who say that their photographic archive should be used under Creative Commons, and Creative Commons should be added to every new job they did, to every new commission they accept. Users may have to agree to Creative Commons, and this is a step which cannot ever be redone. And that was something people weren't aware of when it all started. The use with exploitation rights is something which causes great problems on both sides. So the license holders and the licensees, actually, both suffer from a misunderstanding because very few photographic authors are trained for that. When we're trained in photography, copyright law virtually plays no role at all. Especially those who join photography from other jobs normally have no idea at all about copyright and the law of copyright and copyright contracts. And among the licensees, that's the same thing. And I mean, copyright law is not something which you learn when you study administrative law. So we need to provide more training for that, also in lawyers. And there are very, very few companies that have any competency when it comes to the rights of copyright holders in images. It also means that there are absolutely unacceptable conditions and contractual conditions, as I've outlined, and often they are simply accepted without any problem, and that causes a total economic damage to the whole sector, which is like a write-off almost. Political correctness, appreciation, ideals like fair trade, biolabels, ethical activity is something which everybody loves, but at the same time they mostly exploit us. For those who really are active as creatives in culture and the media, there are different yardsticks which people use. Instead of a proper fee, they offer minimum remuneration and exposure, quote unquote. But that's hot air. You can't live on that. You can't pay anything for that. If you talk about a sustainable company, then you should learn to understand that for us, it's not just the climate that we worry about, but we are concerned with culture itself, which is an important aspect of the development of society at large. And given the current pandemic situation, culture is a very important building block, which, if we get paid for it, saves our survival. As photographer and journalist, copyright law doesn't just help me and stiffen my backbone when it comes to defending my rights of copyright and text and images and photographs. It's actually very important because it gives me a competitive edge. Together with my photographs and the rights of use, I also sell my clients something very important, namely, they are legally free to use various things as they are offered. If I get a contract, I normally test it very carefully or submit it to a lawyer, and then negotiations start. The audience was aware that this was a problem in the video, so the interpreter will continue when she can hear properly. Legal certainty is something which benefits both sides because most of the problems are the result of ignorance or a lack of preparation. After 35 years in my sector, your interpreter regrets this did not work out. Yeah, there was a problem with bandwidth. I think I have a pretty good idea what Heike would have said, and she certainly would have pointed out, and I dress up on my own terms now, that it's essential to protect the individual in the collective. So we do need the help of associations, unions, of all collective structures to make ends meet. I will ask Heike later, and I'm sure it's possible that we can put her presentation on the website in writing, but I think we know where she's coming from because she's already said something good. Hot air isn't something you can live on. What more can you say? Yes, that can't be improved on, can it? But we still live as artists, as authors, in the field of collection societies. We can't gender society, as we've learned. So let us now welcome Christina Oecker, Senior Legal Counsel of VNet. Welcome to you, madam. Hello, and thank you for your kind invitation to both of you, Mr. Hochschild, Ms. Oppenbrink. Thank you for allowing me to be here in the Academy of Arts. I'm happy to see some colleagues, and it would be lovely if there were more people here. What are the consequences we see emerging? Let me, first of all, thank you very much on behalf of VNet that after a very intensive discussion, we can now say this idea of the engine room of copyright. That was a very nice way of putting it because actually the legal package has only been passed just a moment ago. And we've said that we are still very much in the phase where we are trying to find our way around it. A proper analysis will have to wait a bit. The private rights holders, audiovisual rights holders, are now pragmatically looking ahead. We're facing up to challenges that have all been clearly named as part of the consultation process. And of course, as Götz van Einem said, the European law-related and constitution-related issues remain, but are not the subject here now. It's no secret, we made that very clear in the consultation. As VNet, we'd have liked to have a less ambitious and more practice-oriented reform because we can fear and are pretty sure that many of the questions will end up being decided by the courts. The proactive duty of reporting was one of the points that we criticized in the legislative process, that this would have a return effect. But irrespective of this, it is a positive feature that the legislator took considerations that we expressed into account, and the general reservation of proportionality is a matter which has been introduced into that law. Now, this new obligation will come into force from June 2022, and we can already say that companies, as a result, will be faced by huge administrative challenges because it's not that easy. You can't just press on a button and you get the proper result. On the contrary, we're showing, and that's the feedback I get from not just my own organization, but also from other rights holders, that it requires a lot of planning and it's quite a challenge to develop the right organization and administration. Ultimately, Ms. Oppenbrink had to leave us, but I'll just continue. In the end, a lot of effort is being taken, as we've said, and we seriously doubt whether effort and benefit are a bit too far apart. But let's not look at the glass being half empty. Let's say it's half full. So look ahead in a positive way and focus on another issue which we all thought was very important, namely the importance of joint remuneration agreements. This has been further increased, and particularly in the audiovisual area. This is a particularly important element, and I can already say, speaking for my own association and its members, we are using this when it comes to direction, scriptwriters, authors, screenwriters, props, camera persons, and so on. And I can tell you that a press release has been issued today saying that a follow-up joint remuneration agreement has already been concluded between our member RTL Germany and the BVK, which is the German Association of Camera Persons. And that will come into force from January 2022. The remuneration rules for this type of production are completely revamped. And when it comes to fictional production, if this is successful, financial contributions will also have to be paid for the image authors. It's only one example, but it's an important one. And it does show, like the German Cultural Council debate, that discussion, negotiation is the preferred option. Let's get people around the table. Negotiations between companies, authors, broadcasters, all of this is happening and on a level playing field. That has been made very clear. People are serious and all sides respect each other. That's very important, and it brings me back to a demand we would like to postulate for the political future. The sector now needs to have sufficient time to implement without more changes being made or amendments. I think all this means we have to go into the engine room and make sure we can implement. Now we just have to see how to apply this law. Future requirements for regulation will have to follow competition. In other words, after we see what the reality of the law means. And with this, I would like to end by coming to something else important, which also brings us to what we will be discussing this afternoon. The Digital Markets Act and the Digital Service Act. That is, these two will have a major impact on our industry, about the creative sector in general. And we as VALNet demand that Germany, the German government, really stand for creating a level playing field so that the refunding and the refinancing of the media landscape can be made possible. It has a lot to do with needing good national laws like the Media State Treaty and also the media supervision. This is not something which should be sacrificed to the idea of complete harmonization. I think the German government should be very careful here and maybe use the trilogue and try to act in the interests of the creatives and support our industry as a business location factor too. Thank you very much, and thank you also for touching on other issues we'll be discussing later. And those who are with us virtually, GVR is a German abbreviation for the Joint Remuneration Agreement, so-called, which has a lot to do about the appropriateness of remuneration. Now I have to ask a few questions to our makers here. Katharina Umbengt had a sudden attack of coughing. I've got lots and lots of cough sweets and lozenges. If anybody needs anything here, please tell me and I will disburse. Now we've heard our hashtag. We've danced this and I made a mistake. Obviously it ends with RU. I mean, I can't dance it for you. I mean, it's hashtag Zukunft, ZUKUNFT, and then UNARH. I mean, you can do it, you find it on our website. Hey, let's not kid ourselves, you'll find it. With the next guest, the video conference can take a bit more time because we tend to show each other our guitars and so on, but we'll save you that today. Dr. Oliver Schenzer, who is the Scriptwriters Association representative and legal counsel. So now we're talking to him. Oliver, you have the floor. Thank you very much, Matthias. Very many thanks, first of all, for having invited me to both Katharina Umbengt and Matthias Hornschuh. I'm Oliver Schwenzer. I'm from Albacatera, Hamburg law firm, and today I speak here on behalf of the German Scriptwriters Association. Why am I pleased to be invited? Well, I think that this is one of the most interesting copyright implementation efforts in the last decade that we are facing. I can't imagine any other time when we're looking at copyright contract law, which is the subject of this day, when we've had such wonderful changes which are also quite promising for the authors, for the copyright holders, for the creators in Germany. maybe you will allow me to answer, to remind you briefly, Professor Schricker, whose wonderful literature comments have been feeding us all. He died in April this year. I think if he'd be still alive and had seen how to implement this directive, he'd have been so proud. He was a great advocate of copyright contract law. Now, I represent the Association of German Scriptwriters. These are people who are very much active as creatives in this country, in film, in moving pictures. What is it all about? The story. Major American as well as Scandinavian film producers are well aware of this. They emphasize the work of the authors of the screenwriters very much. When in May this year I joined the German Screenwriters Association, I was surprised how underdeveloped the view of the creative effort that screenwriters put seems to be in the general German sectors here. There's a lot more education we need to do here. Because just look at the big American producers, often former actors like Robert Redford or Clint Eastwood. They always say it's about the story, and that's it. So as a result, we need to strengthen authors here. Why is it so exciting how this directive is implemented? I think for the very first time in a very sensitive area, particularly the provision of information, which is what I want to talk about, it actually gives the author more to lean on than before, because there is an enforced, i.e. a compulsory application of the right to information. And that is very, very important, because there is now a great success that you can't really deviate from this mandatory right to provide information, only if you do a different contract. And here I would like to say, from the engine room, there is a new dynamics among the collection societies. You notice that there are things going on, there are efforts to go back to the discussion, to want more, and it's not just the public broadcasters, but it's particularly the big international streaming. And on part of the German Screenwriters Association, we have lively debates with them. But we notice that they are keen to find a conclusion. Why is that? Because I'd like to give you a bit of a legal background, because they are a bit of a triangle, if you like. If you look at the coordinates where you have horizontal and vertical, there are three important directions. Let's say the first element is this mandatory right, compulsory right, where you say any collection society has to provide information. There is no way around it. And the second is that ultimately this particular right, which I referred to a moment ago, can only be sort of delimited through collective agreements, or can only be regulated further through more agreement. Otherwise, it is a law as it stands, and it cannot be discussed. It's like res judicata. And the third part of this triangle, if you like, is the option that collective associations have to act against something that doesn't work. Then you have injunctive rights, and injunctive rights don't mean that you shouldn't report. That is obviously the wrong thing. But in Section 37 copyright contract law, that's very clearly settled. So this sort of triangle is an area full of tension, which we need to balance in order to really strengthen the associations and the creatives. And we hope that this tension there doesn't lead to a Bermuda Triangle for the collection societies either. Maybe very briefly regarding the screenwriters themselves, because I'd like to report on them, because the screenwriters see themselves involved in very difficult negotiations with producers, and that sees increasingly producers intending to buy stories very early on. I almost like to say sort of on spec, to have a stock of stories. Often they are never published. you call that buying treatments. That's basically concepts. These are very strong, powerful stories. The protagonists are decided on. There are storyboards. It all is there already. And I think that the right to information affects this as well. It's not just the commercial exploitation, i.e. when a ready-made film is later broadcast. Let's not kid ourselves. The screenwriter has created something which is copyright protected early on. And there has to be information provided from the very beginning, like what is the amount of the budget for the production, because that will impact the remuneration that screenwriters receive. Now, briefly, how to continue in practical terms with the implementation. This is done by waiting a little because we have some special rules like Section 133, Copyright Act, where in the movie creation area, well, we have to do a bit of catching up to do, and as far as the catalogue is concerned, there are actually pushback to an active seeking of information. Now, that actually causes a problem, because the active seeking of information is something which, in this sector where the film is, the cinematic sector, has always been living in the danger of so-called blacklisting. So the blacklisting is not something which is trivial. It's a very serious problem. I noticed that from all the members that we consult with and who we advise. We also find that authors, whether with good reason or not, are frightened of pushing through their rights, because they fear if they fight for their rights, they might be blacklisted and not get another commission. And that's a serious issue. We need to look at that very carefully. And we need to make sure that when implementing the association's right to injunctive representative action, we don't get the sort of situation, as one of my legal colleagues has said, that you do have to name names and be very clear about what you want. So that is still a bit of an exciting area we'll need to resolve. But before I come to the end, let me say that the implementation of the directive is basically a request to the authors to be brave, to be bold, to make sure that it's not just in collective negotiations that you find some easy or robust regulations. No, you have to be bold, demand your rights. Somebody, Mr. Schulz of GEMAS, once said, those who don't defend their rights will lose them. And that is very much true here, too. It doesn't need sort of court forensics, and it also needs to further define and interpret particular legal terms so that we can make sure that copyright law receives a proper, sustainable status. Thank you very much.
Du wolltest noch zu Ende sprechen, dann
you wanted to finish, Katharina, right? Yes, well, that's true. I wanted to thank you for this presentation, and I think we could have listened to all of the speakers this morning for much longer, and we'd love to continue talking to you about these issues. These are just initial ideas and approaches, and at this point in time, unfortunately, we don't have enough time to have a lengthy discussion. But I think we all want to continue with our debate. Let's take a 10-minute break and return at 12 o'clock. We wanted to give our interpreters a little break to breathe. And also, we wanted to ventilate this room a little bit. I'm not ill. I just swallowed the wrong pill wrongly. That led to me having this coughing fit. And then we'll invite Heike Rost from Mainz again after the break so that she can finish her Zoom presentation. Now? Okay. We can do that now. We're very flexible. Yeah, there's just one aspect which is important and got lost in the unstable internet line. All the creative minds are all the more stronger the more we are. This is why we need to be able to take collective action as well. Unfortunately, we still don't have the right for class action or to take collective action. And that's something that my association has been dealing with for a long time. If you want to sue for your rights to a fee, for instance, in the area of daily news or newspapers, you are most likely to lose your job because as an individual person, it's hard to really enforce these rights. This is why we are in favor of class action. We're rather optimistic that we'll find a path to implement this in the future. So that's something I wanted to add. Thank you very much. I wish you a very successful conference. Let's have a 10-minute break, and I'll see you again at 12 o'clock. Okay, thank you.
Willkommen zurück zur 9. Internationalen
Welcome
Urheberrechtskonferenz
back
in
to
der
the
Akademie
9th
der Künste am Pariser
International
Platz.
Copyright
In Berlin
Conference at the
mit nur
Akademie der
einigen
Künste on
wenigen
Pariser
Minuten Verspätung
Platz.
dafür die nächsten
We're running a little
Konzertminuten.
late,
So ist das
only a
halt,
few
wenn wieder
minutes,
einmal 15,
and
18,
we
20 Menschen natürlich
apologize
an
for
einem
that,
Ort
but
sind.
that's
Aber
how it
willkommen
is
zurück,
when
Zuschauer,
we meet in person
dazu
again,
geschaltet, wie auch
20,
unsere
30
Gäste
people.
hier im
So
Studio
once
in
again,
der
welcome
Akademie.
to all of you
Ja,
here in
auch
this
herzlich
conference hall,
willkommen,
and welcome to
Niki
our
Moller,
virtual
langjähriger Mitstreiter, der so
audience.
freundlich war, sich die
We'd
Fragen
also
aus dem
like to
Chat
welcome
anzugucken und
Vicky,
die paar
who
Listen auszuwählen. Micky, was hast du gefunden?
Mickey, who selected a few questions from the chat for us. Mickey, what did you find? Well, thanks, Katharina. Unfortunately, only one question came in so far. That may be due to the fact that it was a bit difficult to find out the hashtag. So, Matthias, you don't have to try to read out that hashtag again. It's on the screen and it'll appear on the screen quite clear. But there's a question to Dr. Papi. Will the social media license of the collecting society Bildkunst will be accepted? What do you think? Well, I think that the social media image license that we have in the pipeline will be accepted. If you are getting the rights as a one-stop shop, I think that is a good deal for the copyright service providers. Regarding the amount, however, I'm not expecting them to pay the money immediately, and being very happy about it. Of course, it is our bodies and panels who will be responsible for negotiating these amounts. And once we announce the share in revenue or the revenue sharing model, I'm pretty sure they'll not be too excited about it. But you want to achieve an improvement for all of the stakeholders in the sector, and I'm rather sure that some of the service providers in this industry will have to change their mindsets before we can implement all of this. But I'm pretty sure that will move forwards in a positive way. Yeah, that was the only question I had from the online audience. So we have the hashtag that you can see on the screen and our email info@urheber.info, and please write your question in the subject line, because then Mickey will be able to select them accordingly. Well, but we've prepared all of this long ago and made sure that people in this room also have diverging opinions. So perhaps someone would like to request the floor here. No, that's not the case. I think you all agree. What about you, Katharina? Do you have any question? I'm not sure whether all of you noticed that the Senate Chancellery mentioned that we'll be speaking about upload filters. And it's true, the term upload filters was mentioned twice here. So I'd like to address you again, the audience here in this room. Do you have the impression that what we're currently doing in the engine room, in very concrete terms, is directly linked to what we've discussed politically in the past 4 years? I personally have the impression that we've discussed many things that I'm not finding in practice here and now. With upload filters, for instance, we often pointed to the fact that the entire debate could derail. Is there someone who would like to comment on that? We usually don't have the opportunity to look at this from the meta level, if you like.
Dr. Papi, please. Yes, I'm happy to take the floor again. Of course, we all hope that we can use licensing as the main model. However, upload filters, even though they may not be necessary in our heads right now, they still play an important role. This political buzzword was also, let's say, a battle term in the political discussion. It is true that the service providers have to make sure that certain works they are informed about and that go through the entire procedure of the Copyright Service Provider Act, or that is mentioned in the Copyright Service Provider Act, are taken down now. We hope that with licensing and the goodwill of the different sectors, the degree of the upload filters can be very, very low. Professor Holzmüller, you want to take the floor? I think this debate on the upload filters was also due to a lack of knowledge, at least in those groups who weren't using this term consciously to fan the fire of political debate. But when you look at this situation in Germany, we had a very strong situation with a strong duty to abstain, where content on the platforms had to be taken down. And when we look at the new legal situation, I think the degree of liability now is different, which is not necessarily bad, because we can now do justice to certain forms of expression and also implement better exceptions. When I look at the discussion in practice, I think it's also a topic being discussed differently depending on the sector you're talking about. So the answer would either be, I want my content to be removed from the platform, or I want my content to be on the platform, but at the same time receive appropriate remuneration. So the authors who are organized in collecting societies and other associations, and who are right holders at the same time, would most likely say, I don't have anything against my content being on the platform, I just want to be remunerated appropriately, and if the exploitation is going too far or my rights are being at risk, I want to intervene. So whether upload filters is the right way or the classical note and takedown, that's a matter to be discussed. What's interesting is to see whether pastiche, for instance, can still be considered an exception or whether it's a subject to liability. Pastiche has been mentioned several times. Do we have a hygiene rule regarding microphones? Can the speakers get a new microphone when they request the floor, please? And perhaps you can then collect the other microphone. Yes, I just wanted to add one thing here. I don't want to shed light on the entire process again, but there's one thing I find rather difficult, and that's these divides that were created between and authors and platforms at the same time, where, you know, the legal directive, the directive originally is also there to give users a certain degree or a high degree of security. It's not so much about platforms and authors only, but there should also be a strong focus on the users and legal certainty here. So this division that's supposedly there between authors and users is one that is rather artificial, I think, and should be done away with. Yes, thank you very much. There is one last request for the floor by Mickey Moiser, and then we'll move on to the next item. I do have a question to Dr. Schwenzer.
Sie haben über die Verhandlungen zu den GVR
You
gesprochen,
mentioned the negotiations on the statutory rules for remuneration, and that's quite interesting for all of the members of the Initiative Urheberrecht, and there are a few who have not yet started their negotiations. So perhaps very briefly, you can share your experience regarding these negotiations. Are they constructive, or do you think you have to refer the matter to the courts, or you have to fight for the right to provide information on behalf of the entire association that you represent? Well, thank you very much for this question. I think the atmosphere as such is mainly constructive. I'm seeing that the exploiters are also taking an effort to address the associations and negotiate with them. I've been on board only for 6 months, and I was quite surprised to see a position at the very beginning where authors had been seen at the beginning mainly as some sort of day laborers. I can only speak for the Association of the Screenwriters, where also exploratory talks are being done where they're looking at an improvement of the rules of remuneration, of course, also at an inclusion of the right to provide information. And that's true also for other sectors, for instance, the music sector. It will be hard to also include the right to information in the remuneration negotiations there. And if today a platform still states that they don't have that information because it's simply not available technologically, then they're on the wrong path, because I know personally that all this data is available. They do have these data. They have to be made available in financial accounting, for reservation, for possible losses or claims for remuneration. So, and they have to store the data, and therefore there's no excuse for not making them available to the authors. Yes, thank you very much. Those were all the questions so far, and I'd like to return to the facilitators. Yes, thank you very much for these interesting aspects, and also for the new questions that came up directly or indirectly. I'd like to hand over to Matthias, who will be responsible for the European part. Yes, that's true, and we will delve into Zoom now. And let me tell you why things are a bit different today. This is a live hybrid event, and I just heard that today the internet is rather unstable, not only in Mainz, but also elsewhere. So let's just hope that everything works well. If not, you can always listen to the stream later on the internet. So there's a lot to be learned. Something we didn't have to learn beforehand is that we have a great team, the Akademie der Künste team, and Felix Netzer's team, who's the director and is of the Crack company, and is also a very useful link to make sure that this conference works. So we'll move from the engine room to the control bridge, if you like. So we're moving from the implementation into practice to the area where regulation still takes place, and we look at the implementation of the EU copyright directive in Europe, and we do so with the umbrella organizations from Brussels. And I now need to switch over to make sure we have a connection to them. I have a noise cancelling headphone on my head, and I still have to continue
we're gonna switch to
speaking.
English
That
now.
is a real challenge.
To be switching to Zoom. And our first guest in and from Brussels is audiovisual author's point of view. Cecile.
Thank you very much, Matthias. I hope you're all hearing me.
Yes, I am hearing you.
Very good. Hi to everybody online and in Berlin. I'm very happy to be with you, even if virtually, but I think it's better than nothing. I would like to introduce to you the implementation of Article 18 in the member states who have already implemented the EU Copyright Directive. I have a PowerPoint presentation to share with you. So I'm going to start now. I will disappear from your screen if I understand correctly, but I will be with you by voice. Here it is. The PowerPoint is a bit dense, but don't worry, I'm not going to read everything, but you will have it for reference after the conference. So it's the idea is to introduce you to the topic and give you additional info for further read. So I need to find a way to move my presentation. Sorry, I will try again. I'm sorry, I don't manage to move in the presentation.
Felix? Okay. Felix tells me it's up to you to scroll through your presentation because he can't do. Okay.
It's working. Sorry about that. The keyboard doesn't work, but the mouse works. So just to start, for you to understand where I come from, I'm the executive director of the Society of Audiovisual Authors. It's a European association of 33 audiovisual author CMOs in 25 European countries, and we have as our objectives the promotion of audiovisual authors' rights and remuneration, the development of the collective management of their rights, and we also want to act as a contact point for any information on how audiovisual CMOs work and their challenges. My presentation will first address the timeline of the implementation of the directive, to focus then on Article 18, and I will go through the trends of the implementation so far with 3 categories of countries: the one who already have remuneration mechanism in place. Second category is the most disappointing one, I would say, countries with no pre-existing protection and no real will to do anything out of the directive. And my last category is about countries with an innovative approach, and you will not be surprised if I have Germany in it. And I will close with additional resources if you are interested in going further. Let's start with the timeline of the implementation of the directive. You all know that the deadline was on the 7th of June 2021, but most implementation processes have been delayed by the COVID-19 crisis. The Commission started infringement procedure in July with formal notice to 23 member states, and the Commission is following up on these countries. Today, to my knowledge, there are 8 member states who have completed the transposition covering Article 18. So you have the list: Netherlands, Hungary, France, Germany, Malta, Croatia, Spain, Italy, and Denmark only transposed partially the directive, Article 15 and 17. So I'm not counting Denmark in my 8 member states. And we are witnessing an acceleration of process in a number of countries like Austria, Bulgaria, Finland, Slovenia, and Slovakia this autumn. Just for you, as a reminder, I've put Article 18 in this slide. It's a right to appropriate and proportionate remuneration for authors and performers when they license or transfer their exclusive rights for the exploitation of their works. However, this article is quite general and leave it to member states to decide how this fair remuneration is organized. There is a recital 73 that provides for more details on the concept of proportionality, but in general, this recital is not very helpful, in particular for the lump sum payment details it provides. So let's start with the countries with existing remuneration mechanism. In this list, I will focus on the Netherlands, France, Italy, and Spain among the 8 member states who have already implemented the directive. Let's start with Netherlands. They considered that they already had the notion of fair remuneration in their law with Article 25C, so they did not transpose Article 18 verbatim. But most importantly, you have to know that in Netherlands, since 2015, the Copyright Act has been providing a right to fair and proportional remuneration for audiovisual authors that can only be exercised collectively for all forms of communication to the public of audiovisual works, except for VOD exploitation. There is, there was an evaluation of the copyright contract law made by a university in September 2020, which recommended the extension of this remuneration mechanism to video on-demand exploitation. And the Dutch government committed to follow this recommendation. A consultation draft along this line is then awaited in the Netherlands. Second, yes?
Cecile, 2 minutes left. I'm so sorry.
Okay, then I'm going to rapidly present you the French implementation, which I think is interesting because France is among the leaders of the most protective countries for audiovisual authors, with Spain and Italy, and they still found the way to implement Article 18 in different directions. So the principle of proportional remuneration already existed in the law for authors. The Article 18 is only transposed for performers. They made this provision impossible to derogate by agreement. It's what we call public order. And then they provided different ways to ensure that this principle of appropriate and proportional remuneration is respected. I'm not going to enter into the details. Then I'm going to Spain, where here the decree is transposing Article 18, the principle, but we also have in Spain a pre-existing remuneration right for audiovisual authors with mandatory collective management for rental, theatrical exhibition, broadcasting, and online on-demand exploitation. I can refer you to a case study we've made with CISAC to show how the recognition of remuneration right for audiovisual authors has proven effective in Spain. Last countries of this very good trio for audiovisual authors is Italy, which has transposed the principle of appropriate and proportionate remuneration without prejudice to the right to remuneration that is already provided by law for all sorts of communication to the public. And here again, we've made case study that is showing the effectiveness of this statutory remuneration rights for audiovisual authors and the positive impact on the development of the industry. Secondary is the countries with no pre-existing protection and no real will to take advantage of the directive. It's Hungary and Malta. I've not much to say. Hungary did not even transpose the principle of proportionate remuneration. Malta did it verbatim, but no remuneration mechanism is associated. My last category is Germany. I mean, countries with innovative approach, and I've put Germany there. I mean, as far as Article 18, the explanatory memorandum considered that the right to equitable remuneration already exists in the law. But what is interesting for us is that in the separate implementation law for Article 17, there is a right to appropriate remuneration paid by the service provider for the contractually authorized communication to the public. So you probably know that better than me. I will finish with this resource page that we have set up on our website with the recording of online events focusing on the implementation of Article 18, the studies I mentioned, and any legal studies that exist on the topic. And I hope that in the future processes, more countries will follow the line of implementing remuneration mechanism. Thank you, Matthias.
Cecile. Cecile's presentation is even a bit longer than we heard. You'll find that on our web page after the conference. See you later. Back to Brussels, and please welcome Pauline Durand-Vial. Pauline serves as Chief Executive of the Federation of European Songwriters, FERA. She'll guide us through
Directors, Regisseurinnen, Regisseure.
Das hört jetzt keiner.
Alles gut, red noch weiter.
I made a mistake, but I didn't understand the correction. She'll guide us through Chapter 3, Contract Law, and our topic's future in the EU. Law. So we'll wait for just another second. Pauline, could you try to? I don't hear you. Just give me a...
Start? Yes, I can definitely start. Sorry, you froze on me for a moment and I wasn't sure when the cue was going to come, but here I am. So shall I kick off?
Yes.
All right. Hi, everyone. Indeed, again, from Brussels, not too far away from Cécile, actually. I'm on the other side of the same building, so voila. I will talk to you indeed about how the Chapter 3 of the European 2019 copyright directive affects contract law and what the future of our concern is at European level. FERA, the network that I work for, is a network of professional organizations representing and film directors across the European Union and a little bit beyond. We have I think 49 organizations within the network representing directors from over 35 countries. So without further ado, basically, I just wanted to point out a couple of things before moving to key trends in order to stick to the format of 5 to 7 minutes. Our network's involvement on this matter stems from the European copyright reform process, which was initiated in 2014 by the European Commission. And we found very early common ground with authors, representative organizations across creative sectors by focusing on contractual issues. So this Title IV, Chapter 3 section for us was really a very critical point of focus for us in working on the directive. The directive itself is a milestone as far as we are concerned in this matter, as market regulation elements in the European Common Copyright Legal Framework. And in the text, market regulation to the benefit of authors primarily lies in the provisions touching to contractual practices. So these new common standards actually seek to rebalance the systemic weak bargaining situation of individual authors and performers, which is now formally acknowledged by European law. And we really believe that's a tremendous step forward in European copyright legal framework. Now I'm going to share a screen with you so that you can follow the rest of the aspect, because there are indeed a number of different provisions here that are concerned. So it's probably easier for you to have a sort of a visual cue of it as well. So we have a package of provisions in addition to what Cécile just described about Article 18 and the principle of an appropriate and proportionate remuneration, which sets out as follows, basically. So number one would be, after the general principle, Article 19, the transparency obligation, which effectively amounts to a right to information for authors and performers. Do forgive me if I stick to the authors line and I don't always refer to performers, but indeed everything in the chapter refers to both authors and performers contract. Our focus has been very much authors' rights, so that's why sometimes I will skip it, and I hope you will forgive me for that straight away. The Article 20 sets out, through a contract adjustment mechanism, effectively a bestseller clause of sorts, better seller actually, but we'll get to that in a moment. The third part of this initial, what we called transparency triangle, was what the directive sets out as an alternative dispute resolution procedure, which is effectively a way to not go to court in find arbitration in anything that is related to the implementation of these new harmonized rights. In addition to these three initial provisions, the right of revocation added itself in Article 22. And then we have several other aspects of the directive which touch to these new harmonized rights. One is in the Article 23 notion that this triangle without the right of revocation is indeed unwaivable by contracts, which is quite critical what's going to be implemented in industry practice. Representation and collective bargaining are very important notions which are touched upon in pretty much every article from Article 19 to 22. And then in Article 26, we have the question of application in time, which refers to what body of works will be covered when authors and performers will seek to enforce these new rights. Now, each of these provisions, particularly these three initial ones, the transparency triangle, are highly interdependent. The information on exploitation is needed to be aware of the value of the work, so that the right to proportionate remuneration and the use of the contract adjustment mechanism can effectively be implemented. Ideally, we would argue through collective mechanisms, but I'm getting to this in a second. Taking into consideration recent massive changes in the audiovisual market in particular, which is where we come from as a network, with the exponential rise of global players in production and distribution of our work, we identify the most essential aspect laid out by Title IV, Chapter 3, within these provisions as the overall incentive to collective bargaining and the use of collective mechanisms. We believe they are ideal to rebalance the negotiating powers between both contractual parties, but also to bring legal certainty not only to the parties interested in the contract, but the entire licensing chain that will then make use of the work. As the transposition is still ongoing, we can highlight three key general concerns. The first one is that pre-existing legislation is not always up to the copyright standards, contrary to what national legislators seems to lay out in the transposition process sometimes. I think Cécile gave a few examples of that. Different regimes applying to different body of works might well bring difficulties in the consistent deployment of enforcement of these new rights in industry practice, which is going to become a challenge in real life very, very soon. And of course, we have the issue of seeing potentially diverging definition of key notions, but somehow it is less challenging in the text that we have looked at for now than we initially anticipated, but let's see. Because we, in a sort of a terrible scenario, we must still see Court of Justice cases and contradictory case law coming at us in the future, and that would definitely not be helpful. I don't know if I will have had the time to point out to a selection of key notable trends as I had initially planned, but in any case, after rehashing the same. After sort of repeating the same concepts for the last 8 years, I think there is one important point that I'd like to stress today with you. It's that maybe something that we haven't repeated so much, and that is still quite critical. While some of these concepts may pit rights holders against each other, as contractual partners seeks to alleviate the additional administrative burden that these new rights might bring them, it seems really important to take a step back, look at the bigger industrial picture here, which happily some national legislators have done, and observe that some of these provisions bring market regulation solutions to common issues for both authors and performers on the one hand, and contractual on the other, as we seek to anchor intellectual property related to artistic and creative works locally, and to ensure that initial rights holders on a work can effectively benefit from said IP in the context of an increased globalized production and distribution framework, particularly online. Now, do I have a couple of seconds to show you the rest or not? Tell me, Matthias.
Yes, you do, but only a couple.
Okay. So I'll pick, because I have quite a few, so I will share my slides as well so that you can see everything. But if I have to pick one per article, for transparency, I will not mention the injunctive relief for failure to provide information in Germany, which is very interesting. Instead, I will mention maybe the fact that the French legislature has effectively set out the transparency obligation to benefit not only authors and performers, but also producers in the audiovisual sector. Very interesting article to look at if you have a moment. And of course, I'm available for all references needed. On the contract adjustment mechanism, what can I pick? Maybe a definition of threshold for what disproportionate remuneration actually represents in case of lump sum payment contracts. Again, the French legislation there. For dispute resolution, let's pick the fact that both in Germany and in the Netherlands, the proceedings can be initiated by an organization representing authors and not only individuals. Very important way to make sure that the dispute resolution can effectively be used and not be just one of the potential blacklist risk for authors and performers trying to use that mechanism. And for the revocation right, of course, the main problem might be the abusive carve-outs, which are possible under the directive. And it so happens that actually some countries have found ways to include audiovisual works in a very constructive way in the scope of the revocation rights implementation. And in common provisions, some ways to anchor contracts to avoid the derogation in applying these new rights through foreign law, both in Hungary and France. Voila. I think the final point would really be the issue of the applicability in time, which might create a form of layer cake effect, where you have body of works covered by some of these rights and some body of works not covered by these new rights, which are effectively going to be a bit of a nightmare. And there again, collective agreements are really the way forward to make sure that we have a sort of common understanding that bring legal certainty to the entire value chain. And I think that is it for me. I'm always here for questions, details, more information about all of this. And I think I will stop here. Thank you very much.
Thank you so much. This was quite a big impact even in quantity of information. So I can promise you the next speaker won't freeze. He will be here in presence. Thank you, Pauline. And please welcome Marc Dumoulin. He is Secretary General of EXA, the European Composer and Songwriter Alliance. And he'll have a closer look at Article 17, streaming platforms, and our topic's future in the EU. Let's broaden the perspective, Marc.
Thank you very much, and thank you, Katharina, for the invitation as well. Is my presentation on the... Okay.
PowerPoint-Präsentation von Marc Dumoulin von der EXA funktioniert. Felix Schnetzer von unserer Agentur eilt zur Hilfe und wir hoffen, über Doppel-, Dreifach-, Vierfach-Klick die Präsentation dann doch starten zu können. Natürlich hat es im Test funktioniert und jetzt nicht, aber ich bin sicher, die beiden werden das Problem doch noch bewältigen. Frage ein, ja, Till.
Gute Idee.
Wir würden dann an Micky Meuser nochmal übergeben, der uns die erste oder eine der ersten Fragen aus dem Chat vorlesen wird. Vielen Dank, Micky.
Man muss husten, damit man gehört wird.
Okay, I guess you have to cough into the microphone to be heard. Okay, thank you. We have 100% question increase, meaning that we have two questions now. One was rather general. If there is a violation to my copyrights, should I call a lawyer? I don't think we have to answer that question here. Ms. Sitte from the left-wing party Die Linke has a question on the first round. And I think that question goes to you, Mr. Nolte. Why shouldn't the cake to be shared grow? May be understood as a polemic question, but I take it very seriously. Well, experience shows that incomes are increasing continuously, but YouTube is an ad-financed platform, and the rule has always been that ads will only be shown if the rights holders want that and also commission that, and part of this revenue goes to the rights holders. I mentioned 4 billion for the music sector last year, but when you look at the overall figures, you can see that this is indeed a pretty big share of the cake. And Article 17 doesn't state anything that would lead to an automatic increase, but of course we hope that the revenues will increase. May I add that advertisement also has to do with your trade in data, namely that with your system you can collect and gather a lot of data of your music consumers on the platform, and that also is a considerable value, which may be even higher than that of advertising alone.
Yes, thank you.
Handing over to the panel.
Start now. So just a few words before I start about EXA. EXA represents over 30,000 professional composers and songwriters in 27 European countries. We have 59 member organization representing all music genres. Our main objective, of course, is to defend and promote the rights of music authors on a national, European, and international level. Our members in Germany, I will spare you my my very bad German, but you can see them all here. Just to run into the topic, so Article 17, I think you all know what Article 17 is. So, but what I wanted to note is that the European Commission, of course, published its guidance on Article 17 on the 4th of June, so basically 3 days before the deadline for implementation. For us, it's clearly not a step in the right direction. It intends to encourage, more safe harbors, in a way close to the German implementation as well. It also encourages more copyright exception, and there is also the exclusion of the rights of reproduction from the scope of the guidance. But if we look at the implementation, so as I was saying, for us, the German implementation has raised some concerns regarding the minor and presumably permitted use. Such uses are still subject to the remuneration obligation, something which is not the case in certain other countries that are following the German implementation, as an example. But I think if we look at the EU overall, it's fair to say that many EU member states implemented Article 17 in a positive manner for us, close to the wording of Article 17. This is the case of France, Denmark, the Netherlands, Spain, Italy, Croatia, and I think the last one has been Ireland in the last days. At the same time, we've seen harmful implementation also presented in Finland and in Austria. And we could expect some negative implementation as well popping up in certain late EU member states. Now, just a word about the Digital Services Act, which is a proposed regulation that is now under the legislative procedure in Brussels with both the Council and the European Parliament. The objective should be indeed to increase the responsibilities and oversight of online platforms, and something which is very important for Article 17 is that the DSA should be coherent also with other lex specialis directive, like the AVMS directive, for example, and not intend to modify those pieces of legislation. For us, the DSA should lead to stronger liability regime for online platforms rather than creating more safe harbors, of course. However, we've seen lately in the European Parliament and in the Council that both institutions are kind of moving away from that goal. And we think it's a missed opportunity. Together with a lot of cultural stakeholders, we signed recently a letter to call on the EU policymakers to stay true to the original objective of DSA and ensure due diligence for platforms. Now, I will turn to other issues that we see as very important for the future, because, of course, in our view, the Copyright Directive was a key improvement in certain areas, notably with Article 17, but of course with also the whole Chapter 3, Articles 18 to 23. But another issue that we've seen popping up, especially in the UK, is music streaming. So with, it has been clear in the UK, but it's also true for the rest of Europe, and indeed for the world, that it's almost impossible for music authors to get decent revenues from streaming today. So we have published a paper in May this year, which looks at the different issues linked to music streaming. Of course, one of them is in the copyright directive, as I was saying, for user-generated content platform with Article 17, but there are a lot of issues with streaming that still needs to be addressed by Europe and by the world in general. For us, we have identified the issues of transparency, the issues of how streaming works in terms of the user-centric versus the market-centric approach. And also one very important aspect is music data, which is an issue today for publishing. So as I was saying, 2019 Copyright Directive is of course a key improvement, but it will not solve many of the streaming issues that we have today. So talking a little bit about what has been happening in the UK, there was a UK DCMS report which started with a campaign, with two actually campaigns, the Broken Record campaign and the Fixed Streaming campaign, led by our member in the UK, the Ivor Academy, but also by the Musician Union, in the UK. It led to the DCMS committee to publish a report on the economics of music streaming before the summer. What are the key recommendations? They want to implement a copyright reform in a way similar to Articles 17 to 22 of the Copyright Directive. They also want to tackle the disparity between song and record rights holders, something which is very important for us, of course, undertake a review of music metadata, and the report also supports a right to equitable remuneration for performers. One issue that is very important, really key for us, is the issue of the lack of competition, we believe, in the music market, with, of course, the free music majors really having a big dominance and a negative impact, which leads to the share of streaming revenues going much more to the record producers rather than to the publishing rights and, of course, to the music authors. So what is interesting is that in October, so quite recently, the UK Competition and Market Authority, the CMA, announced that it will launch a market study on music streaming. And we hope, of course, that the European Commission, with its competition power, will also investigate music streaming. Another issue that we are very much focusing on is buyout contracts. So we published also in May our vision on how Europe can prevent buyout contracts. We have focused our study on audiovisual composers, and we have undertaken an extensive survey to ask them about the impact of buyout contracts. In this paper, we also explain the main characteristics of buyout contracts and put forward recommendations to prevent them in line with the Copyright Directive. Just a few figures about the results of our survey. So the key figures here is that a majority of our members have experienced buyout contracts. They have also experienced a growth of those contracts in the last 3 years. And there is also the ongoing issue of coercive publishing, which a lot of our members, 2/3, which have been offered contracts which forced them to sign away partial rights, such as sync rights or mechanical rights. In the meantime, of course, as you know, the VOD market is really much growing with a lot of revenues, and I think it's even truer with the COVID-19 implication. So what is the buyout contract shortly? So as you know, usually for a screen composer, you would have a commission fee covering the period during which the composer creates the song. And then you would have royalties covering the composer's participation to the revenues generated by the work. what is happening with buyout contracts is that you have only a one-time payment, a lump sum, basically, that will compensate now and forever the composer's contribution to the work. And in parallel to the lump sum, what we are seeing as well is that those contracts are qualified as work made for hire, pursuant to the provision of non-EU laws, in particular US copyright law. So to fight about those contracts, we urge the Commission to look at it, but also EU member states have a role to play in the implementation. We ask them to implement Article 18 in a mandatory manner. That's something that France did recently with screen composers. That's an interesting move because basically there are any contract that would prevent an author in France to benefit from the protection of the French law. Any contract that would go against that would be prohibited and invalid, basically. Also, in Article 19 is really important because it's about the transparency, and without transparency about the exploitation revenues, it's of course impossible to get a fair remuneration. There is also one aspect which is important, is that in parallel to the implementation, the Commission is looking at collective bargaining agreements and competition law. And for us, too often, and this is an issue which is also shared by the directors and screenwriters, and too often, competition law has prevented authors and their contractual counterparts to collectively bargain, basically. And the European Commission is looking at this, and it's something that we really want the Commission to make a real important step on this issue. Just to conclude, some recent updates. The European Parliament has adopted recently three different reports. In those reports, there is a clear expression of a strong concern against buyout contracts and asking the Commission and Member States to prevent them. There is also the clear ask that the European Commission should assess the role and impact of streaming services, both audiovisual streaming services and music streaming services. And of course, they also call on new member states to speed up the implementation of the Copyright Directive and ensure access to collective bargaining.
Thank you so much, Mark. Thank you. Keep it. If there aren't any questions right now, are there any questions right now? Just one, okay, yes, Mickey?
But a short one.
Yeah.
You'll have to.
Well, I don't think we have any. Sorry, it's microphone number 5. I don't think we have any questions from the internet, but I do have a question concerning the buyouts. We heard Cécile Despringres. She said something that in France, and I know you're from France, Mark, they have the implementation says you cannot be deprived of the fair remuneration by foreign contracts. There's a clause like that. And we know that buyout contracts usually come through that back door. In Europe, everything is fine, and it's against the law to have a buyout contract, but then the film producer presents you with an American contract, and you're really proud to be signed international through the US, but that's a buyout contract. And can you state something that France is closing this back door, and could that be an example for the whole of Europe?
So I will maybe answer partly to a question, but and also see with Cécile if she wants also to answer. But I was referring to the implementation of Article 18 in France, but which has this special provision only for screen composers. So for screen composers, basically, if they sign a contract which would be under the work made for hire and under very often a US jurisdiction, it would be deemed as illegal.
So we have come. We do have to come to an end of this first half of our conference. Thank you so much, Cécile, Pauline, and Marc. We wouldn't be here if you weren't there for us. So you are so important for us. It's brilliant what you do. Thank you so much. And I found the mistake I made of obviously FAIRA represents screen directors. I wrote it down the false way. So let's have a break. Obviously, I need one. Katharina.
Ja, willkommen zurück 13
Yes, we will be resuming at 13:30, so we're going to have about half an hour's lunch break. We're very happy that so many of you are with us. After all the things that the technicians tell us, the audience is still interested despite the glitches, and that you are very much involved in asking questions. So as we had hoped, it's a bit more lively this way than if we just had little pictures on Zoom. Thank you very much, everybody. We'll meet again at 13:30. See you then.
Yeah, I hear you.
Willkommen zurück zur 9. Internationalen Urheberrechtskonferenz der Initiative Urheberrecht in der Akademie der Künste am Pariser Platz in Berlin als Livestream auf unserer Webseite www.urheber.info oder bei Vimeo. Sie, liebe Zuschauerinnen und Zuschauer, können auch gerne teilnehmen. Nutzen Sie unseren Hashtag oder senden Sie Ihre Frage an info@urheber.info. Hier stellen Sie Ihre Fragen bitte im Betreff der Übersicht. Zurückwillkommen heißen wir auch die ReferentInnen, die bei uns vor Ort geblieben oder für den Nachmittag dazugestoßen sind. Wir werden uns erst einmal wieder nach Brüssel begeben. Bevor wir uns
First of all,
im
we're
vierten
going back to
Teil mit den
Brussels
aktuellen
again
Problemen
before we
auseinandersetzen.
tackle the
Gemeinsam
fourth
haben wir
part,
das,
which
haben wir diesen
concerns
Teil
current
hier
problems
nach der
in
Wahlforderungen an die
Germany.
Politik.
And
Wir
after
hoffen,
that,
dass
we
der oder
look
die
at
eine oder
post-election
andere
demands
Adressat
to
zuschaut oder
politics.
zuhört.
We
Und das
hope
haben wir ja
that
schon
some of the other of
festgestellt,
our
dass das
target
durchaus
audience will attend, and
Und wir
we've
möchten
heard
schon mal darauf
before that they actually
hinweisen, die
do.
Konferenz bleibt als
So let me
Aufzeichnung
tell
auf
you
unserer
also that
Webseite
the whole conference will be available on our website, so you can watch it and also point out to politicians. If you want to have a really good assessment of the situation, and then you can tell them about the stream of the conference, 2 hours, 39 minutes or something. I'm not sure what that means. I'll tell you later. Well, you are now going to tell us about DMA and DSA, and after all, who knows what that is? Yes, that is a big question, and sometimes we don't need to ask it. It's often very difficult. The first discussion, what? I don't know what that is either. Can you tell me? I'm involved alongside, as it were. We are just starting to take a bit of a deep dive into it, but I was requested that before we get our experts to talk to us, we explain just briefly what it is really all about. And you see, we always come back to the e-commerce directive, 20 years old, which had to be finally replaced. Way back, they dealt with the necessary promotion of online business, and of course, given the extremely successful existing business models and some giant players, obviously it's no longer necessary to help them along. Finally, people have understood that. Then we also had the AVMSD, Audiovisual Media Services Directive, which was mentioned already. And then we also have the Digital Market Copyright Initiative. And in the beginning of 2020, the Commission decided they would make that last step for the digital single market and complete it. So they had the Digital Services Act, which was a legislative package, which has 2 parts, namely DSA and DMA. One is the Digital Services Act. So it's about hosting providers, platforms, and then there is also the DMA, which is the Digital Market Act. It's all about creating competitive yet fair markets in the digital sector. I'm not trying to be premature. Marc Demoulin has already touched on some of these issues, particularly with a view to the copyright directive. But we now have some very interesting guests, and they will provide questions, comments, and in Dr. Jungblood's case, additional information to help us along. Matthias, over to you. I would like to ask the next 2 speakers to come on the stage because they know the details a bit more. We've got 2 high-caliber experts. One comes from the world of books and the other from the world of film. So let us welcome Peter Kraus von Cliff, the president of the Federation European Publishers, FEP, in Brussels, and Christiane Sommer, producer at Laserfilm, but here today as Spion, the top organization of the film industry representative. Thank you very much for inviting me to be here. And to all the organizers, very many thanks and a lot of respect. I'm sure it's not that easy to run such a hybrid event with all its imponderables. I'm very happy to speak to you, wearing my hat as the chairperson of the FEP, but also as the Exchange Association of the German Booksellers Organization, which is representing the trade as well as the publishers. I think it's a perfect time to talk now about these 2 big directives that are planned. We see a great chance for restoring the balance of power between these big, powerful internet platforms, of which there isn't a single European one. The European creative sector has a deep mark on the whole thing, but all the platforms are US American or now also Chinese, but it's the medium-sized German creatives that create the content. I'm very happy that my colleague is here as well to tell us about some of the important points, but some things are very important to us that have to be really tackled today, because you may remember this morning, much of the DSM was not implemented in quite the way it was originally intended, and we certainly do not want a reconquest where the things that we were able to push through in Brussels will be taken over and changed by the two planned directives. I'd like to surprise you with two figures here, which illustrate the balance of power. It tells you annual expenditure for lobbying work in the European Union in millions. The 10 largest automotive factories, 10 million euros, the metalworking companies, 30 million euros, and the number of meetings of lobbyists with the EU Commission at the end of June 2019, meetings that dealt with legislative packages to reduce the power of digital companies were 271. Share of these meetings where lobbyists of these companies or the associations of the digital players were present, 75%. So you see that some of the points regarding the DSA and the DMA need a bit of retroactive adjustment. We see some opportunities as well as some problems, and we're happy that some of the ex-ante obligations for the providers can be quite useful to us. For example, the ban on self-preferencing, access to data, and so on. The gatekeepers, that's the big platforms, they obtain their market power by running platforms which provide things in the market, but they're also like a spider in the web. But if this market power moves over to other areas, the companies stay in our systems. But normally they act as, for example, in my areas, publisher as well as book choice. Gives you huge marketing power, and through the marketplace you also have the gatekeeper function, while at the same time a provider of content, and that is something which the DMA hasn't really addressed yet. The obligations of the DMA to do something in these markets actually requests a better definition of what constitutes ancillary services. I try to make that clear on the example of Amazon, because that also needs to comprise trade and distribution. There's a huge gap in protective rights which needs to be closed. For the consumer, it's often impossible. It's a core platform service or an ancillary service they're dealing with. The DMA at the moment does not make a very clear distinction. That is not to the purpose, and it can't be true that Europeans are later and less restrictive in delimiting this power than the Americans are doing it. You may have heard about the planned US law, the American Innovation Choice Online, that has already passed the Senate. After all, the EU should not fall behind those efforts. And another point for some of you, maybe a niche issue for the book sector, absolutely convincing, is interoperability. The publishing houses provide data, and the data are then used in the ecosystem, bit of an odd word, isn't it, ecosystem, in their economic system, one should say, and they then encode these data in such a way that any reader cannot change the device. In other words, you have to read that content on this reader and not on another one. We want to be able to give consumers in Europe the choice as to which reader they use for reading the content, and that they can also get a new one without re-lending, reborrowing or licensing. We need to get a ban for proprietary ecosystems be delivered with the readers. It doesn't make sense to us why the Council hasn't done anything about that yet. And the book sector may be small. It's a bit, however, like a sentiment survey, like the miners having a canary in a cage with them. Once the canary drops dead, they're threatened too. And in the European Parliament, there are always many good proposals for the area of application and for interoperability, and it would be really good if we could achieve something here. IMCO is the Single Market Committee of the European Parliament, and the Cultural Affairs Committee have also moved things forward a bit. Briefly on the DSA, before I hand over to Ms. Sommer, I think I don't exaggerate if I tell you that we are extremely disappointed about the status. And when you're looking at this, and it's all something you can read at Lobby Control, you really ask yourself, Where do these arguments come from? We are concerned about the many exceptions from the rule regarding offline is illegal and online is illegal for small companies. Why should companies from the digital sector be free of law and order? There's a lot of effort for the small publishing houses to keep to all the rights. When we're talking about image rights, even the smallest right we need to obtain, rightly so, and it's the same with music and everything else. So why is it that offline something is illegal, which is considered to be perfectly legal once it's online? It also doesn't make sense why from out of a clear sky the Council has decided to say that if you're looking for something, how do you look for illegal content? You use a search engine. So one example is the Ololo search engine, and please don't Google it. That is a search engine which provides an optimized projection of illegal content. And we'd be very happy, Dr. Google, if the search engine issue was just be kept out of it, because it's an alien body which has nothing at all to do with the matter in hand. And ladies and gentlemen, we also need to effectively be able to remove illegal content. We think it's a positive thing that the Council has been extending the trusted flagger category and open it up to companies as well, so that together copyright violations can be dealt with and tackled. The expertise should be important of the group and not just one individual. And we would be happy if the Council would defend this in any further decisions. But we think there's been a wasted opportunity against this constant uploading. It's a bit like a dog chasing its own tail. I mean, once something has been uploaded, it would need to be downloaded again, cannot be completely removed. We're not talking overblock. The constant repetition is something which is a great effort for small companies and even more so for individual artists and authors. So we want to notice and stay down. So let's not have that content uploadable again. So that would be just one example of what is at stake, and I'm happily hand over to a colleague who's more involved. Dr. Jungblöck, however, there is one overarching objective. If something is illegal offline, it should be legal online as well.
Thank you very much to all of those who organized this rather complex event. I'm very happy to be representing SPIO, which is the top organization of the film industry and represents German films along the value-added chain, starting from the production to the reproduction in cinemas and also on platforms. SPIO now represents 16 professional associations and more than 1,300 member companies. Julia Meyer-Hauch, the legal counsel of SPIO and director of European Affairs, is also here with me. She's a specialist for European legislation regarding the film industry. Film as an economic branch is often underestimated. So I'd like to start with a few figures. In 2019, the film industry had a turnover of around about 10 billion, half of it being generated by production companies for TV films and feature films. Altogether, we have 123,000 people working in the film industry. In 2020, there was a big collapse, as you know, and that has affected the film industry greatly. We're speaking about 4.8% less jobs subject to social insurance than the year before. We're mainly talking about small and medium-sized enterprises, many independent, smaller companies in the film and cinema sector. Now on the Digital Markets Act, on behalf of the film industry and also the Publishers and Booksellers Association, together with the German Publishers and Booksellers Association, we want to achieve a fair remuneration and a fair balance. From the film sector's point of view, there's a very important module, which is transparency. That means for us in the production and lending sector, the use use of films on platform has to be represented in a transparent way. Currently, for film producers and lenders, this is a black box because we don't know how the films are being used on the platforms, how many users watch them, how many clicks they get. This is mainly intransparent. Netflix has shortly launched a so-called transparency offensive. However, they only looked at the top 10 at Netflix based on 2 minutes screening or watching time, which is far away from any other regular measurement methodology and does not give any useful information. So this is an area where we have to improve greatly, because only by knowing how our films are being used will we be able to make sure to get appropriate remuneration. So how can the Digital Markets Act be of help here? Well, not very much, because the European Union restricts itself to a triangle contractual relationship. However, we would like to have a two-sided or bilateral contractual relationship between the streaming services on the one hand and producers and lending companies on the other hand. So in order to avoid the negative impacts of gatekeepers on the film and bookselling sector, the ancillary services of gatekeepers have to be added, these ancillary services of the gatekeepers, as Mr. von Cleff just mentioned. So in Amazon, that would be Amazon Prime and Amazon Prime Video, of course, mainly for the film sector. So whether book or film will profit from the DMA is really a tightrope walk, and it really depends on whether ancillary services are included per definition or not. Only if that is also included and also covers the film and the bookselling sector, the obligations regarding access to data and interoperability will come into force. Now, the European Commission and the European Council are currently not willing to reduce this to a bilateral agreement. A few remarks on the DSA and a few figures. Gold Media and VMet conducted a study which shows that the audiovisual sector loses more than 430 million euros a year because of illegal streaming. For Germany, that means that social contributions and taxes to the tune of 100 million euro are not being paid. And if you look at connected markets such as the hospitality business and cinemas, these losses are even higher. I think we're speaking about around about 170 million. This is something that has to change, and therefore the DSA, in addition to the DMA, is a very important legal package to create certainty for the copyright. Now, digital piracy has increased by 36%. The UK-based Federation Against Copyright Theft has taken down or is taking down an ever greater number of illegal content. So I can only repeat what Mr. von Cleff said. What is illegal offline also must be illegal online. What's important for us is that the notice and action procedure is implemented as foreseen, and that there's no distinction between different types of content, and that also the deadline does not exceed 24 hours, because for both the book and the film sector, it's enormously harmful to have illegal content in the net. So for the cinema and also for certain book types like investigational novels and so on, it's important to take them down as quickly as possible. What's also important is that the AVD directive still takes precedence over other directives on audio and video on demand. And I think I'm finished, and I'd like to hand over to Mr. Jungblut now.
Du von deinem Pult ab und wir begrüßen Herrn Dr. Jungblut,
Yes,
Leiter des
thank you very much. I'd like to welcome Dr. Jungblut from the Federal Ministry for Economic Affairs and Energy, Head of Division Legal Framework for Digital Services. Ladies and gentlemen, thank you very much. This is indeed a very topical event because on Thursday, two important digital projects are on the agenda at the Competitiveness Council in Brussels. And as things stand at present, the Council will unanimously adopt a general approach on both projects. First, on the DSA, and Germany has been calling for a revision of the old e-commerce directive for a long time because it really dates back to a time where today's companies haven't even existed. And we really tried to make sure that the notice and action procedure is harmonized in Europe. We have a patchwork agreement at EU level. It's due to the copyright directive, also the German Netzdurchsetzungsgesetz and other regulations that exist at European level. Therefore, it is important to look at this horizontal legal framework again. And let me just tell you, both of these packages are regulations, so they can be applied directly and immediately. They don't have to be transposed into national law. So we have welcomed the fact that both regulations have been presented in their draft form during our presidency. And we also support the fact that the European Commission has a stronger role with the DSA. Now, this is new. The French fought for that, and we said, yes, we want to stick to the principle of the country of origin, but with the DSA, we want the European Commission to be active. And we also like the distinction between bigger platforms, so-called gatekeepers, and smaller platforms. There may be some things that you are interested in. Yes, search engines. Can we pass European legal acts without including the search engines? Well, they are included now. They are subject to due diligence obligations that includes all types of search engines. But yes, you're right, they should also be covered by liability obligations. Now, drawing a line to copyright, the recital says that regulations looks at specific rules and regulations. I think that is a clear line also to the AVM directive, the Audiovisual Media Services Directive. Then we have an exception for online marketplaces. I think that also has to be discussed because there is the aim to cover all different services, service providers. Trusted flagger. That's an issue. I'd like to use the example of priority boarding. You know, in the past, when you went to priority boarding to catch a plane, you were surprised that the lines or queues were longer there. And the same is true for trusted flaggers, because if you only have trusted flaggers, you'll be queuing there, and the line next to you is free. So it's important to not only have collective claims, it can also be single companies that should be able to follow their claims. We are now starting the trilogues with the DSA. I think the European Parliament in the committee will take a decision on the 9th of December, but with the DMA, I think the vote will take place today in the committee. Now, on the DMA, I'm a cartel lawyer, so I've left this field a few years ago. ago, but we also decided to increase the legal framework here. The competition law has not proven to be helpful in the past. When you look at the Google shopping case and how long it took, and it went all the way to the European Court of Justice, I think I recall my minister noting that back in 2015 even that Google shopping case is taking too long. So these ex-ante rules are very important. We need strong duties and obligations for gatekeepers. You've mentioned a few already. And I think we're looking ahead to two difficult or tricky trialogues. The DMA trialogue may be a bit easier. The French presidency wants to conclude both procedures during their council presidency. That may be true for the DMA, I reckon, but the DSA is really rather complex, so that may be more difficult. Perhaps a few remarks on lobbyism to end with. I've had more than 80 talks since February this year with several platforms, professional associations, collective management organizations, and some organizations I had never heard of before. I even had to ask my kids who they were. So thank you very much for informing us about the latest events in Brussels. I'm also happy to take your questions.
And from our side too, we are very happy that our two speakers are now available to answer questions either from the people here or from the chat. I'll start with Ricky, who's done the selection. Well, there wasn't that much to select, but there is a question to Mr. Klaus van Cleef, and the question concerns the DMA, Digital Markets Act. What can the DMA, the way it stands now, help the book trade? Pretty general question, but I'm sure you can answer. Thank you. It's a quick answer. The way this DMA stands now, it doesn't really get us anything much. If the money bags look their money and can use their demand without any obstacles against us just because the market constellation isn't multilateral, the DMA doesn't help us at all. When we're looking at the antitrust law side, we are speaking with one voice here. According to antitrust law, it means that you have several people in correlation, not that you have market players that are so big that they don't need anybody else to play with. So unless we have this multilateral constellation, as Ms. Sommer said, if you don't get the negotiations to make sure that we have a level playing field for several, the DMA won't get us anywhere. Thank you. May I now ask for questions from in here? And if you don't come up with a question immediately, I'd like to ask a question regarding the procedure. Dr. Jungblut, you work in the German Ministry of Economic Affairs, but you speak as though you have a lot of influence in Brussels when it comes to the implementation of both the DSA and DMA. What's the role that Germany played in it at all? That might be important for all of us. Now we are making experience with how to implement the German Copyright Act. Thank you. Well, my very first experience was that as Germany, however large a member country we may be, we are just one voice among many. And something which I really noticed with the DSA in Brussels is that there is a large group of member countries who we call the minimalists. It's a good dozen member countries, particularly from the Eastern European area, which were very happy with the proposal that came out of the Commission and which rejected any way of making it more stringent. And there was another group. We were part of that group called the Maximalists. We had other demands for both the DSA and the DMA. It was a different balancing act for the Slovene presidency to find a solution with these two different groups. And the Commission, which has supervision over the search engine, the big platforms, the French used that in really smart political way, and there was a big gesture. We supported the French in it, but of course then there was criticism coming from other countries. I named but two, Luxembourg and Ireland, who are very keen to maintain the country of origin principle. There was a comment, not surprising with those two. The speaker continues, we did try to bring the German position to bear, but in the negotiating position the way it is, we couldn't really push through everything we wished. And another supplementary question, it's now a regulation which needs to be implemented, and that's true for all the countries everywhere in Europe. No, it's not. I mean, when you have a regulation, when both these regulations mean that the DMA will come into force 6 months after it has been published, and according to the current status of things, the DSA will come into force in 18 months. What we have to do is we have to look at existing laws. We need to look at the network enforcement law, for example, or some others. When it comes to the DMA, I don't think there will be a need to adapt and amend existing laws. As far as the DSA is concerned, who's being the digital services coordinator? In other words, which authority will be responsible for those platforms active in Germany? And you're right, there are not that many of them. Any other questions to the coordinator? We've had two people asking a question. If the DMA doesn't sort what we need it sorted, we lose out. I think, as Dr. Jungblut said, and I also alluded to, the regulation will come into force. And you said, well, we don't have to amend some of our laws. We do have a good, well-functioning GBB with the Section 19A, but I think it's going to be pushed aside by the DMA. And yes, Germany only has one voice, but I think we have to be very clear that Mr. Schwab, for example, is in the European Parliament. He's part of the IMCO committee. I can only say we request politics to make sure that they have an eye to the German media market and that they don't lose out on what we've achieved. The Media State Treaty, the law against unfair competition, that we just sort of sacrifice that as you would sacrifice an animal on the altar of others. We shouldn't do that. It would be disastrous for us, for the members, and for the creatives. I mean, we have to put it like this, otherwise it will be a platform protection law. I can only agree with you. And actually, there are two comments I would like to add to that. In 2019, because Ms. Sommer gave us all these timeline, 2019 pre-COVID, in other words, the turnover of the European publishing market altogether was 24 billion euros. That was 5 billion euros less than Facebook alone had in profits that year. 260,000 people work directly for publishing houses in Europe. And if the 5 billion that these people altogether generate is 5 billion less than the profit made by just one of these platforms, you will see the imbalance. And once again, piracy is a big issue too, because things which are taken out and are immediately uploaded again almost identically, that's a cynical issue, and we have to do something that this is no longer possible. You can't just have a directive and then what you've described, the German Unfair Competitions Act, might be undermined. Dr. Holzmüller, please. I would like to ask a question to Dr. Jungblut, a concrete question, particularly with a view to the next panel, which will deal with remuneration for private copying. So what's the levy for private media devices according to the German law? We're dealing with a problem that many of these devices are not introduced by official importers, because if it is, then the private copy fee will be done. But usually it's a sort of shadow market trade. Matters are ordered in China, hard disks, all sorts of devices, and then collected by the end consumer in Germany. Normally there would be no private copy remuneration payable, so the German importers rightly say this is a distortion of the market if they don't get their fee. Now, at the beginning, we thought the DSA would help because we thought that would be a more stricter regulation of the various trading platforms, which would also entail liability, which they would have for such violations. The way I understand it, no liability of this type is planned for those people active in the platform. But the new business customer rule, could we not understand this like that, or at least put it in such a way, change it in such a way that we can make sure that whenever devices or media which are carried and so via platform, that then the trader pays that remuneration? Well, my experience with the DSA is that there are that many specific questions. I mean, we have illegal product piracy, we had copyright-protected measures, now we have devices with private copy remuneration fee. But the new business customer principle exists for online marketplaces. In other words, the marketplace needs to get certain data from the trader that doesn't actually include whether or not the trader paid this fee. And the trader has to set the website up in such a way that the relevant data can be automatically uploaded. Safety by design, quote unquote. The private copy remuneration or fee, that is another issue. I know that the two ministries, Ministry of Economic Affairs and Ministry of Justice, are going to tackle that. We had ideas of that, but there is some question as to how to do that. I think the system is no longer such that we can say that what is happening today isn't necessarily something that falls under that law. We'll have a presentation on that in a moment, actually, and then we will see. There was another presentation. Check then someone from the chat very briefly. I don't want to run the danger of having everything done in very general terms. I'm going to put it in general terms. When you're looking at the fact that in cultural policy terms, we are dealing in a sort of struggle also with the transatlantic sphere, where you have the big Anglo-American companies. And we've always felt that in Europe, the call for more consumer protection has always played into the hands of these people, because then it was intellectual property right protection against consumer protection. So my question to all the panelists in the front, as early as now, how can you look at this when you're looking at the new government that's forming in Germany? Do we need to worry that, once again, consumer protection will destroy many regulatory ideas that were supposed to protect us from American companies? Or do we have a momentum where we recognize that German cultural politics needs to be reflected more in what comes out of these matters? This is always due to the question as to how important German governments consider culture to be. And recently, we weren't really top of the agenda. We certainly saw that during the pandemic. Culture was sort of an also-ran. We obviously tried to change that with a lot of means at our disposal. And the authors, producers, we try to strengthen them, their position, even though apparently their position is weaker than that of the big players, who usually are not located in Germany or headquartered in Germany. We don't want to lose hope. All I can say is I'm very much in favor of having this momentum, and I'm pleased it exists. And we're doing all we can with all the other organizations, including SPIO, to actually push that along. Consumer protection doesn't mean everything has to be convenient. It means that those who have the rights and the consumers all need to be protected. Politically, economically, if you sort of maximize everything, you say make it as comfortable as possible for anyone, and then say, oh, I didn't know that there was copyright in this. There was an almost tragical discrepancy I'd like to point out. Apparently the notice and takedown, or stay down as I call it, is so difficult difficult technically, but increasingly in transparent guidelines make sure that some rights disappear. For example, we got a children's book, and that's disappeared because it's called PICMIC. There's some internal guideline which meant that book has disappeared. And if you don't understand why that is so, well, at the same time, somebody says, well, I can filter that, but I can't do a notice out, stay down. I think it's absurd what's happening there. I think consumer protection sometimes has to be you protect people against themselves. It's unpleasant, but it means a bit of backbone is needed, and that's what we can expect our politicians to provide. Maybe in general terms, another issue, DSA and DMA means that Europe is indeed taking an important step forward, particularly when it comes to the transatlantic relationship. The Americans, both in antitrust and other matters, are considering passing some more moderate laws. Whether that will pass through in America, we'll have to wait and see. But in both these areas, Europe is sending out strong signals. And the Koreans are looking at what we're doing, the Japanese are, and the Americans also. They scrutinize that extremely carefully. So there is an important political objective behind it all, even though there may be many minor things that you don't agree with. Well, it's 1:15, and I'll intervene. I have a lot of questions myself. Convergence, distance from the government, all these are issues which are very important, and we haven't even talked about that yet. A balance between, diversity and uniformity. I mean, all of these matters should have been discussed. Now I have to ask you to move this way around, away from the speakers, because this is where my card is, which tells me what do we do next. Thank you very much for what you've just all said.
So, hier werden Geheimnisse aufgedeckt.
So here we are revealing some secrets, at least to me. I'm looking at my card and it tells me we're coming to the fourth part, to pre- and post-elections, demands to politics. And I'm really looking forward to, honestly, I've been looking forward for quite some time, because we've got a pretty high level in these contributions, quite broadly based. I mean, today we can do that. And but now we're showing a face that is worth being here today. I'm really looking forward to that. But now you will see what it means for culture to have a lobby. And right now they have a lobby in the UK in particular. We're really happy that we have a very successful songwriter and musician with us, somebody who writes for The Guardian, and somebody who's part of the campaign Fix Streaming, where she's been, well, active in really fixing politics.
Do I get a microphone?
Yeah.
Yes.
Might be.
There it is.
Quite nice.
Thank you. Yes. So I'm, as was said, I'm a songwriter. I'm from the Irish Academy in the UK. As you might be able to tell, I don't have a British accent. That's because I'm Swedish originally, but I've lived in the UK for quite a long time. Now, I don't know if you might have noticed, but the UK is no longer in the EU. We definitely noticed on our side, we had campaigned so hard for the copyright directive, and then we left the EU, so what to do? And on top of this, the pandemic hit us. All right, you're gonna get, yeah. The pandemic hit us, and so we were affected in that way as well. But the kind of silver lining on that whole gray cloud was something that we had campaigned for a long time, which was to fix streaming, to where we get so much less than artists, and it's impossible to survive on streaming income, as anybody who's a composer or songwriter knows. And we've always had had an issue getting artists on board, but because of the pandemic, when suddenly they all lost all their income from live, there was no live income to kind of paper over the cracks for them. And suddenly a lot of artists started looking at their royalty statements and they realized, wow, this is not, I'm not going to be able to survive if this is how I'm going to survive for the next few years. So for the Ivers Academy, we anticipated a loss of £25,000 per person during COVID. And these were for the composers and for artists, probably a lot more even. So we took the opportunity to reach out to the Musicians Union, whose members were also having a lot of trouble to survive during the pandemic. And we pooled our resources for the fixed streaming campaign. And I think this is what really helped us to kind of move this ahead a lot, because the Musicians Union, well, it's a union, we're not allowed to unionize. So we had a lot of power behind us with having the Musicians Union. We helped them to campaign for the equitable remuneration, which would mean that their members would get paid for streaming, which they weren't currently, in particular the session musicians. So we started a public petition. We came up with the name Fixed Streaming because we like saying what it does on the tin. And we collected over 18,000 signatures. So the actual campaign started last year. We also started lobbying policymakers and informing our members, because we realized that a lot of the time people don't understand how they're actually getting paid during streaming. And we had target media pieces and a lot of social media. So we got more and more artists on board with this. We also have events and panels, and we started working alongside Broken Record, which is was launched by Tom Gray, who's a board member of the Ivers Academy, and also an artist. So he had kind of started a campaign online just to explain how record deals work and how they're not working for us in the streaming age. And after all this campaigning, 5 months into it, Lord and behold, the government said, yes, we're going to look into this. So the Digital Culture, Media and Sports Select Committee announced that they were going to do an inquiry. And so we all sent in submissions, everyone, all the stakeholders in the music industry. We had personal testimonials from big artists, smaller artists, songwriters. And I think it's quite important for songwriters in particular, because for us, we're largely invisible. I'm a songwriter that is not a performer, so I don't even get credited on streaming a lot of the time. We prepared oral evidence, and it's still available online if anybody wants to watch, because it's actually quite interesting to see all the songwriters and composers and record labels and streaming companies testifying in front of the DCMS. We were helped a lot by one of the members of the DCMS. So the panel actually is both Labour and Tory, and one of the Labour MPs that were on the DCMS committee is actually a songwriter and an artist and an MU member and an Ivers Academy member. So he explained a lot of the background to the rest of the DCMS, because in particular for songwriters, it can be quite complicated to try to get a message through. It's not as kind of simple as a lot of the messaging that, for example, streaming companies put through. And then we also did a campaign, the second part of the campaign, where we had a lot of big, right, I know this is really tiny for you, but you know, it's some of the biggest songwriters in the UK signed this to the government and said, you know, you need to look deeper, including, as I'm saying, Jimmy Page from Led Zeppelin. We have had quite a few with Paul McCartney, Elton John, people like that. So what did we want? Well, we developed the issues during the campaign with the Musicians Union, and we had the Nile Rodgers, Tom, some other songwriters and artists from all walks of the life in the music industry testifying. And actually, in the end, the Select Committee found in favor of all our campaign demands, including a complete reset of streaming. And so basically, what we then, this is actually not on the screen at the moment, but what for us, what we wanted for songwriters was transparency. And I know transparency is one of these words that can mean just about anything. But for us, the biggest problem that we explained to the government was that we can't literally, well, we can't audit the streaming companies. And while we can audit our publishers and record companies, it's impossible to actually get a clear audit because we don't know on what basis we're being paid. And we do understand that non-disclosure agreements exist in commercial, in the commercial arena, but surely there must be a way that we could actually be able to see on what basis we're being paid, because how do we know that we're getting paid correctly otherwise? We also wanted a look into metadata, which is a big problem for us. Actually, let me go back to this one. There we go. Here, suppression of value of the song. I'll start with that one. Because it was mentioned earlier by Mark briefly about the negotiations. Why are we paid so little as songwriters? Well, and why has it been stuck at 15% for so long? Well, we said something is really not working when the record labels own the major labels own the major publishing companies. And they earn a lot more from a record deal than they earn from a publishing deal, which we explained to the government. So, you know, in a record deal, usually the record label gets 80% of all streaming revenue, and in a publishing deal, they get 20% of a streaming revenue. So, of course, we're seeing that they would favor the label side of that. And so the vertical integration needs to be looked into. So we raised our competition concerns. So the record companies are, it was reported that they were starting to feel the heat from that. And then also fair contracts. Again, fair, a word that is, you know, can be anything to anybody really. But again, transparency triangle, we tried to kind of push through without saying the EU copyright directive, because you know, it's a sensitive issue with our government to do anything that the EU has done previously. But we were saying, well, maybe we can have an even better ecosystem in the UK, that we can, you know, certainly we should not be inferior when music is such a huge export for the United Kingdom. And then Kevin Brennan, who is actually the man there, he's where sorry, I've switched off my sound. Oh, turn it down on this. Sorry. Okay, that's a good idea. Thank you. Yeah, so Kevin Brennan, that's that's the MP on the select board or select committee that is also a musician. So he actually, and this is a bit different in the UK. Any member of the Parliament can put forward a private member's bill, and it just so happened that he managed to get his bill through right in the follow-up to this. To our campaign, so he's able to actually push even further for a discussion in Parliament about everything that we've discussed in the fixed streaming campaign. And it's what he wants is equitable remuneration for performers, which we mentioned before, and which Mark mentioned as well, transparency obligations, contract adjustments and dispute resolution, and right of revocation. So a lot of it you can recognize actually from the copyright directive. So here we go back to the poor metadata. So we actually have brought this up a long time ago, that metadata is a huge issue. And basically it's, there's conflicting registrations, there's missing registrations, and we predict that at least 30% of all royalties collected in streaming are unallocable, which means that they don't know where they should pay them out. And instead, what they do in the end is they pay them out according to market share. And of course, if it's paid out according to market share, most likely it means that some companies get paid twice. And who has the biggest market share? We get back to the whole major label, major publishing issue again. And most likely, if there is a metadata problem, we say it's probably the independents where the metadata issue has appeared. And because nothing had been done, even though we had launched an inquiry into this in 2018, we thought this was a good time to talk about it again. We did research in the beginning of August, where we estimated that the song streaming data gap is at least £500 million per annum that gets lost in so-called black box. So this money is currently not reported by CMOs or the representatives, meaning there's a lack of awareness and transparency on this problem. So we launched this autumn another campaign along with a music rights awareness organization called Credits Due to ensure complete and accurate song metadata. And actually what we're asking for is there should be a minimum viable metadata requirement for all songs that are being streamed or even being submitted onto streaming to DSPs. So anyway, to kind of round it off, I know I saw the time is, I need to round it off, so I'm skipping through. We also launched along with that something called the Pay Songwriters campaign to do in the meantime while we're waiting for all these legal changes and for the Competition and Markets Authority to investigate, because actually the Competition and Markets Authority did agree that they would look into this. So they've started a research into the dominance of the major publishers and the major labels. So in the meantime, as they're doing that, we asked that the labels should pay songwriters a per diem just to cover expenses and also give us points from the master, which is a short way of actually tipping the scales a little bit more for songwriters and composers. You can online, you can find the response from the government. As I mentioned earlier, the government agreed that this needed to be looked into, but as most governments tend to do initially, they ordered research and studies into it. So we've all launched new research into how this is all affecting us as songwriters and musicians. And also, we've set up, along with the Intellectual Property Office, a contact group of representatives of all stakeholders in the music industry to look into the contract transparency and also the data issues. So we're working with the government on this. And I think that we've, just to kind of round it off, to kind of inspire other organizations, is I would recommend to work together across the industry and to sort out any disagreements that we have outside of, like, in private, so that we can go as a united front to the government, because I think that is what ultimately helped us get to where we wanted to go. And to also obviously protect and support all the big names that have the courage to stand up and speak to government representatives and legislators, because I think that is what has so long been missing in our campaigns. People need to put a face onto the music creator, and once you do that, I think there's so much that we can gain across the board. Hopefully that helps. And if you have any other questions, because I know this is very short, I can be reached via my Twitter or Instagram, or I'm sure that the good people here would be able to put you in touch. I'd be very, very happy to help if you feel inspired and if you feel like you want to launch something like this in your own region.
Coming to be with us and for your absolutely fantastic and inspiring presentation. That was really many clear ideas. I would like to say what you've provided was more than ideas. It gets us plans, and maybe we can join forces to find joint ideas and plans. And sometimes we can work across borders, even newer borders, and I think cooperation is still possible. And this afternoon, a lot has already been debated about these. Even across the UK borders, we've done it with the copyright directive to some extent before it all happened, and we've worked together with so many in this room, with people from the book industry, the music industry. Time and again, we find that there are objectives that we can jointly fight for. I'm going to be brief, don't worry, because now we will hear from Dr. Matthias Röder. He is the managing director of the Herbert von Karajan Institute, the foundation, where he is also a member of the board. And he will look at streaming from a very different aspect. But later, all the speakers will be available for the final discussion. Matthias, first of all, you have the floor. Hello, Matthias. Right, ladies and gentlemen. Innovation, that is... Is that my mic? Am I doing something? Well, innovation is the engine, the motor of society. Without innovation, no prosperity, and the basis for all of that is creativity, and that's what this conference and our business is about. But creativity in this society has a bit of a tough job. Not just that it's hard for us to get to where we really need it, schools, the boardrooms of the companies, and often culture is made harder, difficult. We're prevented, we're condemned, we're not efficient, oh, you're all daydreamers and what have you. But it's very important for us to have clear culture. What would society be without music, literature, film, art? What would society be without the creative spirit of inventors, without the creative spirit of entrepreneurs? Human creativity isn't just something you must enable, you also must protect it. It's of essential importance for our society that the money gained from utilizing these art forms goes back to those who've created it. If you don't pay the creatives properly, who else is to create something new in the future? Who else will drive us forward? And that brings me to the central point of my very brief intercession. The money which creativity generates normally doesn't get to where creativity started. That money stays somewhere in a sort of morass of intermediaries. They don't get to the table where money is distributed. It's calculated down, it goes to nice fleece covers or rugs and red carpets or for wonderful clothes and are distributed elsewhere. It's particularly drastic when we're looking at streaming. Let me share with you some concrete examples from my everyday experience. Here is an artist whose music, 3 to 5 million people hear his music every month. That is somebody who you should consider as well-known and successful. I find it hard to believe that this sort of artist, somebody who's got more than 150 million streams on different platforms every year, gets a low 4-digit euro sum from the platforms for that. So between 1,000 and 3,000 euros to make it clear. Well, you can use that to live of it 1 month maybe, but not here in Berlin. How many artists have got 3 million people listening to them every month? How many have got 150 million streams a month? So you can imagine what that means with the mass of the creatives, how much they get out of it. On balance, far too little ends with them, and things continue. If as an artist you want to increase the poor streaming genres and are doing disciplined social media marketing that everybody is talking about, what goes up is your own costs. Occasionally, you also see your own streaming numbers rise, but the value of the individual stream is fluctuating because it's dependent on the overall number of streams and the subscription income of the platform. So it could quite easily happen that you have more streams and you end up even less license in the way of license fees. Please imagine the price of a book depends on how many other books were sold. Or just imagine your legal fees as a lawyer. Your hourly fee depends on how many hours other lawyers work. Unthinkable, isn't it? And I could give you many, many more examples. I can't understand either. In the year 2021, we still have annual, best case, 6 monthly calculations and accounts. Every kid knows that blockchain allows you immediate and transparent accounting. The intellectual capital of an artist, how can that be used effectively? If your music, your text, your recordings, and all the data which are generated through all of that isn't made available to the artists. Sometimes you find sales processes that go years back in the accounts. Streaming accounts contain absolutely zero information about the time or place when somebody called up this particular musical stream. You can't really make it worse, and you can't levy on that, put a levy on that profit. The way that the collection societies, the way the labels work, the platforms works, they take away the creative basis of the very business that people live on. I find it impossible to understand that. It's quite common in our industry that the accounting rights which are enshrined in law are massively cut. Look at our industry practice. To some extent, there are contractual rules saying only internally generated reports can be issued as the basis of an audit. They categorically deny any information provided to contracts with third parties. They massively restrict what auditors can do. So how should creatives, how should authors get their rights if it takes years to enforce these rights and usually costs hundreds of thousands of euros? I'm not a copyright expert, I'm sure you notice that. I'm not a politician either, and I'm not an artist, but I'm a member of society. And I find it absolutely horrifying what's going on here. The value of intellectual capital of artists should be protected. Our creatives need fair, transparent, and honest pay. Copyright law has many good ideas in it, and all the people behind this initiative here are people I'm very grateful for too. But it's very important now that the authors, the creatives, get better tools to push through their own rights. Many bright minds contribute to innovation. Innovation needs courage, freedom, and a lot of creativity. And this creative achievement needs to be worth it for the artist. Nobody lives on air and love or does click-through rates. Thank you. A very, very warm thanks.
Das rutscht raus, oder? Ich glaube, ich sollte da eigentlich nicht dran rumfummeln. Nicht, vor allem, wenn ich dran bin. Besser?
I hope you can hear me. Okay, I'm just talking for the sake of it. Okay, it's working. Thank you. Many thanks. I think you've all realized that this really fit what we heard earlier. Could anybody get me a roving mic, please? Because mine doesn't work here.
Ich hatte da jetzt einen längeren Einschub an der Stelle, der darauf hinausgelaufen wäre, darauf hinzuweisen, dass soziale Absicherung eines der Megathemen der nächsten Legislatur sein muss. Wir wissen nach Corona,
safety nets are very important because we've known even before COVID that without a viable sort of social security background, there is no chance. But we know what will happen. I'll save you the rest of what I plan to say, but we really need instruments. We need not blunt swords, but swords with a very sharp edge. I said already, the protection of the individual can be created by the collective. However, did I put that the right way? The protection of the individual is the collective. Yes, I got it right.
Im Kollektiv.
So it's the collective where we can obtain protection, and how we can do this, we will look into that now. Professor Dr. Caroline Meller-Hannig is our next speaker. She is a civil law professor, civil law and trade law at Halle University. And last year, on behalf of the Verdi University and the German Journalists Union, two very important organizations and unions in Germany, she was commissioned to do a study, and she developed a draft law. The title of that product, which is worth reading, which you can find in the light, is Representative Action in Copyright Law, rights for everybody, one contract, simple. One could also say, well, justice for all, just do it. All right, we would make sure that we get our technical link up with Halle and with the professor who is waiting there. Welcome and hello.
Okay, es geht los.
We can continue. Thank you very much. Hello, ladies and gentlemen. As you now know, I'm a lawyer. So obviously the angle from which I look at the subject is very much an academic and legal one. But of course, it is all based on one important statement. Authors regularly find it difficult to legally put through their right for appropriate remuneration, even on the basis of standardized, simplified contracts. Often, fees are paid which are below what is acceptable and appropriate. And it is consensus in legal policy that copyright has a social function, and copyright contract law should make sure that the often not existed. And the sound has stopped. There was a problem about disrupted contractual parity, and there is a legal right to remuneration. How to procedurally enforce this involves a lot of effort and cost, a lot more cost sometimes than you get paid as a result of it, even if you win, because there could be a disadvantage in going to court, because when you go to court, the identity of the person pursuing the case has to be revealed, and the creatives, that is my experience, don't like doing this because they fear the results, and that is not something which only we academics say. It is actually stated very clearly in the materials on which the DSM directive is based. Charges are brought primarily by the people who intend to leave their jobs. So there is a gap in the legal protection, and having no sufficient legal protection means there is an obstacle in obtaining right. But the effectiveness of legal enforcement depends on how people stay true to the law and how we can sanction any violations of law. So it's a general, not just an individual issue. And in such cases, individual legal protection needs to be added. And what we need to add are collective legal protection instruments. And particularly important here is representative action. What we collective opportunity yet all throughout all sectors, particularly as a reaction to the introduction of a possible representative action. Many contracts have been cancelled and terminated, and at the moment there is no general rule about this. Whether anything new, whether even collective bargaining agreements can be concluded on this basis is still not clear. It would be very sensible to have representative action, collective or group action for copyright purpose, where there are no collective bargaining agreements or anything similar. Being allowed to take representative action would have the advantage of allowing a streamlined and effective proceedings to be run, and the individuals concerned do not have to participate or even be there. It has a preventive aspect, and as we all know in the legal profession, is that it could also have major effects on other matters. We know the same thing happening in consumer protection. We know it in labor law, where it's being discussed, and for consumer law, representative action is going to be mandated at the European level, because an EU directive, yes, yet another EU directive is being planned here, and that will make it possible for associations to go to court on behalf of copyright, and especially repeated violations of right should be able to be brought by representative action. That will then also help with video context. We're not talking about individuals, we're talking about press freedom, we're talking about creative rights in general. So what we need is representative action, which will on the one hand protect the rights holders, but which on the other hand will effectively push through the legal right to appropriate and fair remuneration. And this is possible. The tradition of the various injunctive relief acts have made that very clear, pertaining to consumer protection. And all these very clear frameworks in the civil proceedings can be solved pragmatically and easily. Courts can deal with such cases, even in areas where there may not be existing laws. We've had no problems in practice, at least to prove that the amount of remuneration paid out is inappropriate. The European directive you mentioned also allows abstract cases to be brought, and it also allows unmandated action. And I think representative action hasn't yet been made possible. We would like it, but maybe when the European Representative Action Directive, it will be possible to have a wide enough scope to cover copyright law as well. But there will be representative action which will have a model character, and that will hopefully also impact copyright law. And until next Christmas, that directive will have to be implemented into national law. Well, ladies and gentlemen, I can only wish you a very good conference and a lively debate. Thank you very much for listening to me. Thank you very much, Professor. And we've been really lucky that the sound and the picture completely gave up only towards the end, although your interpreter regrets it was a bit iffy in between. The issue of representative action is an issue which many of us have been talking about and thinking about for a very long time. We were positively surprised when at the beginning of the year, before even starting the implementation of the directives, the two unions, DJV, German Journalists Union, and Verdi, commissioned this study. And as we've just heard, what she's envisioning goes beyond this, and it certainly goes beyond what might happen in the next few months. If I understand it correctly, what she said, 2 or 3 of her statements concerned mainly the media sector, because that was very much what she was commissioned to study. And, well, that's how I interpreted what she said, but yeah, I'm happy to be corrected if I got it wrong. Several times during the day, we've heard people say, be brave, be braver. And I think the prospects for the associations and the trade unions are good to work together, to work in a way that it can really help protect authors and creatives better. And if they can act together for that, I think it would be a very good idea. I would like to leave it as that. The professor is still available for questions, but sadly she only had time to be with us until 3 o'clock, but we'll now move over to the next exciting issue, which we've already heard about. We heard about mentioned this morning earlier, and we now hand over to Professor Compton.
Tino Gerlach von der GVL. Vielen Dank zum Thema Privatkopie.
Dr. Thilo Gerlach from the GBL on private copying. Can you hear this? Yes, wonderful. Thank you very much, Katharina and Matthias, for the introduction. I think what Grundig once said when he was in a board meeting, he said he thought he was in a hospital because so many people were having doctor titles. Perhaps we should just leave those titles away for the next conference. I'm representing the GVL, and at the same time I'm president of the European umbrella organization of the CMOs of performing artists with GVL. I've heard I'm with the artist side, and GVL as a collecting society is a member of the ZPU, which is the umbrella organization of all German CMOs, and we are the platform for the private copying remuneration. This is something that has been mentioned before, so it's not a comprehensive reform that we are trying to achieve, but we want to be able to do smaller adjustments. We heard quite a lot from Brussels already, and there are some things that have not been harmonized neither by directives or regulations, and amongst them you find private copying. In Germany, private copying is allowed. There are clear advantages of that rule for users because it means there is a freedom of use, no copy protection measures that are taking place, and data protection in social media is also being guaranteed. And since we're talking about streaming, we all know about the discussion of our ecological future when we look at climate change, and streaming just requires a lot of energy and uses up many, many resources. Private copying, however, is only allowed when it's accompanied by a remuneration system, because private copying is an encroachment on the rights of creators who should actually be able to decide for themselves whether and who may use protected works and performances and under what conditions. So this is permitted by law, but only if accompanied by an appropriate remuneration. So the appropriate compensation has to take place, otherwise private copying would be unlawful. So as a rule of thumb, we could actually say if a private copy is permitted on whatever device and with whatever technology, a fee must be paid for it, not, of course, for any individual act, which is hardly ascertainable, but across the board for all the devices and storage media, and especially if it's not about licensed content. So there are, however, considerable gaps here. Firstly, it's about the devices and storage media that are included in the private copying regulations. So protected audio, video, text and image content is then sent out via WhatsApp, or synchronization takes place of a multitude of mobile devices with the cloud. These activities have so far taken place without any remuneration. I think we're speaking about more than 40 million private copies that are made in Germany every day and are not subject to a system of remuneration. And this is why we have to include virtual storage in this obligation to pay a fee. This does, however, not apply to reproductions within licensed digital offerings. Then there's something that we call operators' remuneration. You may know this from copy shops, where payment must only be made for paper printouts. So any paper on a USB flash drive is not covered by that. Now that's a distortion that we have to stop. So including devices is one step, but it's not helpful if remuneration is not appropriate. And here we have clear deficits where especially the right holders who have to live off this type of income during the COVID crisis and beyond are clearly affected. You may remember the so-called second basket that reformed this idea of private copies, where the copies were to be empirically proven, so the storage medium, the devices being used, and then accordingly, and in analogy to licenses, a remuneration was to be paid that represented the value of these copies. Back then, companies said if our licenses are too high here in Germany, then people will buy their devices abroad, and then the right holders won't get anything. So that led to a regulation that the remuneration must be in an economically reasonable relationship to the price of the device to correct for this distortion, if you like, economically. Where are we now regarding provisions and regulations? Back then we had fixed amounts in the annex to the German copyright, and they had not been changed since 1995. Now we have general contracts being concluded, but there is disagreement with so-called outsiders who are not a member of the associations negotiating and concluding these agreements. You can now refer to the arbitration board in the German Patent Office, and they are now trying to regulate this system with a quite surprising result. The board of arbitration says we want to avoid remuneration being in an economically reasonable relationship to the price of the device. We want the license to have such a low amount that this never happens. How do you get this low rates? Well, you just look at this old annex of, it's not 1995, but 1985, looking at the fixed amounts. Just imagine what this square, this place right here, the Pariser Platz, looked like in 1985, and you may also recall the purchasing power back then. And now they're trying to link up to these tariffs, to these rates, and combine them with the number of users, and also add a factor of digression. And as a result, you have tablets, for instance, where all parties to the contract agreed on €8.75 being paid to the rights holders. So that was laid down in the joint agreement, and right holders are quite surprised when you look at the number of copies taking place over tablets. And the Board of Arbitration has turned this into €4 according to their approach. So this is an approach that tries to avoid this correcting step of economically reasonable remuneration. So we call on the German legislature to amend the provisions accordingly, provided that you accept the price of a device in the first place, because this is really an insult to artists, to be honest. I'm not saying that anyone won't buy his or her tablet in Germany because they have to pay €8.75 regarding fees to the copyright holders. Just wanted you to have a brief overview of what's going on in German legislation. So I'm all the more happy that Dr. Jungblut just stated that policymakers are going to deal with this in the next legislative term. Something I'd also like to share with you is that I just recently went to the Ministry of Economic Affairs, where we spoke about the so-called second basket and tried to articulate our interests. And the Ministry of Economic Affairs then replied, well, you're in the lion's den here. And I asked back naively what they meant by saying this, because we are from the creative economy or the creative industry. So now with the new legislative term, I really hope that these distortions, as I said before, are going to be corrected. Thank you very much, Thilo Gerlach. Yes, that is something that was discussed during the last legislation, and we've received clear signals that policymakers are going to look into that again. And we know there are some representatives of politics who take a rather negative stance on this topic. We're running a little late, ladies and gentlemen. We have to move on to a different topic. This is something that will be certainly on the agenda pretty soon. It popped up in spring last year. Suddenly, e-lending, in the context of a legislative package, there is a clear interest in solving this issue, especially on behalf of the book publishers and publishing houses, and also on behalf of artists and creators. And I can only stress again that it's not only individual authors, it's illustrators and other professions from the area of copyright who work with and for books. And we'd like to start with Christian Schumacher-Gebler, Managing Director of Bonnier Media Germany, and Nina George, writer and President of the European Writers' Council. I think they'll be very brief in outlining what this is all about. It's a rather sensitive topic, e-lending.
3 Minuten, oder? Ja? 3, gut. Ja, also
3 minutes.
einerseits Geschäftsführer der deutschen
Yes, it's true. I'm the managing director of the Bonnier Media Germany publishing house, but I'm also a member of the board of the German Committee on Publishers. And this committee very urgently communicated that there is a clear need for action with regard to e-lending, and especially the question, how do we deal with digital content in the libraries? So you think this is a clear niche topic? You can. That's what I also thought, that I could ignore what's going on with regard to e-books in libraries, but that's not the case. And in the past, many individuals from the industry wrote on that, but they never did what we just heard here, also in the keynote, that you need to put a face on your claims, and that the greatest degree of protection is in the collective. We had a campaign called Fair Lesen, Reading Fairly, where people from the book sector came together and they signed a petition where we expressed our demands to policymakers at the beginning of coalition negotiations. And we asked them to look at this topic of e-lending very cautiously and sensitively at the same time. So we want authors and writers and all of the parties involved, also the book trade, to be part of this demand. Where is the big problem? Now, in 2020, we had 66 million e-books consumed, or read, if you like, and half of them, 30 million, were subject to e-lending, that is, they've been consumed over libraries, and 30 million were sold. The problem is that the revenue side, which says, yes, we sold 44% and we were lending 46%, is extremely distorted because only 6% come from libraries and 94% from selling the books. So we're stating that 254 books generate proceeds from lending, and the rest is being generated from selling the books. These figures are ridiculous because we're moving closer to 60 or 70%, and any percent that we get in addition, at the lending side will be lost at the sales side, and this will reduce the amount, which currently is at 270 million euro, even further. This is why we ask policymakers to not pass provisions that these books have to be made available online as an e-lending book, but that this model of selecting e-books from so far, 365 days a week, something that no longer has anything to do with going to a real physical library, is something that we find is wrong. It can't be the task of policymakers to have a text-financed lending model where you pay a contribution of 10 euros a year for libraries, and that this would include all the e-books. Yes, we like people to lend books, but this is our Kindle Unlimited model, which will not be sustainable for the future. Yes, great. Thank you very much. And we often hear this from different stakeholders. It can't be the authors, the writers, and the artists, and the book trade in general to compensate for what municipalities don't want to invest in their libraries. So I think that is really the distortion that takes place. Am I right? Yes? Okay. So we do agree, and we would like to add Nina George now. Yes, and I do have a little button in my ear, and I've heard Nina already. So I think she's here. So theoretically, Nina, you can start right away.
So there you are.
Leg los.
You can start. Thank you, Matthias. Those who don't know me, I'm Nina George. I'm author and president of the European Writers' Council. Before I will go into e-lending specifically with regard to Germany, I would like to talk about the analog and digital issue in public libraries Europe. Basically, literature knows no borders, and the challenges arising from that for the creators are not simply limited to national legislators. Especially once your books have been translated, you get a lot of new, exciting disasters. For example, you've got a printed book in a Danish library, and you find out that the library fees in Denmark only go to local, never foreigners. In other words, you get paid nothing. Or you find that there are no library fees, such as is the case in Romania, Portugal, and Bulgaria. Bulgaria, though, they have workshops where Creative Commons teach library representatives how they can work against the public lending right, which would be a duty of remuneration. And the European library organizations are also in favor of controlled digital lending, and they are making a lot of advertising for that. What this actually means is that you can scan printed books that are part of the inventory of a library, then you can offer them for online lending without asking the authors and without any further pay for the users. And this type of usage of simply ignoring exploitation rights and copyright laws actually make remuneration ridiculous. And what about the right of the public? They're using the right of the public to have access to books in a way which is unilateral. They play with the public against individuals. In 2020, the Instrument Archive, which is a sort of emergency library, open its doors, and what they do is 1.4 million digitized printed matters were offered for download worldwide without any agreement of the authors, without any remuneration. Anybody who publicly denounced this was publicly shamed. Then he or she was then told, you hate your readers. And then there were blacklists that were drawn up of authors who complained. And people were then asked, don't buy the works of these authors anymore. I'm an author, and I've been translated to English, and I've been published in New Zealand. And what can happen to me is that the New Zealand National Library, they've just donated 400,000 printed goods from their overseas collection, i.e. non-New Zealand authors, to the Internet Archive. So here again, they scan, they digitize, and make available in the open library for global download, no license, no fee, no pay, no remuneration of any kind, and most of the goods are still under copyright. So both nationally and internationally, we reached a point in this history of relationship between authors and libraries, which is not all that new. Since the first photocopy technologies, microfiche, were invented, the morally charged conflict ensued, how the lending of books by libraries was to be organized. In other words, who pays and what sort of conditions should exist. And we see that the digital environment is much more a battleground than ever before, but the digital library offers tend not to be any different from commercial offers, certainly not the way they're handled. But the difference is in the excellent price for the users and the extremely miserable remuneration, if any, for the authors. Accordingly, even in Germany, 42% of all the e-books read are obtained through online lending, but that only contributes to 6% of the electronic book market. And if you look more closely, I, as an author, when a 10-euro book is sold, a printed book, I get between €1.34 and €1.68 for that. As soon as I give that book to be in any library, the price reduces. In the Amazon flat rate, a 10-euro book, the digital lending would get me 36 cents. If I did it in a library, there was a digital lending between 0 to maximum, very rarely, 9 cents. If I then were to give the book as an analog print book to a library, I get 3 cents. 4.3 cents. And that's what the Standing Conference of Education and Cultural Ministers has been calculating. By the way, that is about the worst in Germany, and you can imagine that that doesn't really cover anything. At the same time, German authors are incredibly under-informed as far as lending in Germany and the conditions therein concerned. 805 authors, and I just got the raw data 15 minutes ago. A survey of all these authors showed that more than 90% do not know how often or under which conditions their e-books or their printed books are actually being lent to readers in public libraries. And I really have to say, you have to do a lot as far as transparency, the duty of transparency is concerned, because otherwise I can't really understand that anybody should take seriously your demand for appropriate remuneration for authors. In March 2020, the German Second Federal Council wanted to start an author's rights law. It is the duty to contract is included therein, and that means there is a mandatory license, and under this license I have to give all the details, but have really poor conditions. One group would then be forced to inform a state that they to provide a state with their creative achievement, which they've done under private economic conditions. And I think this is totally unacceptable. So I would say, let us stop to use copyright law and the right to remuneration and play it off against the right to culture and informant. The solution is not another law, the solution is pay. Thank you. You heard a round of applause here. We can't discuss this matter anymore because we've run out of time, but you talked about public shaming of authors, and you've just given us a very good insight into the abyss that opens up if, like you, somebody has really been fighting for the rights of authors. You mentioned shaming, and I feel ashamed, I must say that, because, I mean, we're good friends, and I quite forgot to properly introduce you, so that is shameful. You're a writer, bestseller author, recently became an author of children's book as well. Then next time you have a strong smell. It could be the book of Lina and her husband. It's called that. And she's also president of the European Writers' Council. So, I mean, for fairness' sake, I really had to say that. And now I would like to also thank our previous speakers. The two of them have been a brilliant pairing. And pairing, working together, that's what today is all about. I have to take this thing off, it's horrid. Time and again, it's a wonderful idea to look at copyright people and their partners pay for state-run organizations doing their job. We should consider maybe the people who are in ICU should actually pay for the training of nurses. After all, it's in a good cause. I keep asking myself, how many of those who make that sort of demand without even blushing, how many will buy fair trade products, organic products, and think they're so sustainable and so conscientious? If you want to protect chickens in the rainforest, what about authors and artists? And since I'm at it, I'd like to point out on something else in this context. It's again about libraries and about another urgent requirement for regulations, but this time it's about games. In the copyright initiative, we have the game authors as well, and they are looking after the interests of those who invent games. And it would be an urgent request to say that what they create should be part of the DNB German National Library catalogue. The idea is that a legally recognized basis for the legal rights of getting paid by libraries for the games being borrowed. Analog games would also finally receive long overdue social recognition as a cultural commodity, and their importance as a medium for education would also be recognized. I'm stumbling over my own words as a speaker because I'm trying to rush through it so fast to save time. So if we had games in the National Library, that would be a definite win-win. Since the three parties which are likely to form the new government has said that they would be positively disposed to that, maybe there's hope it'll happen. Thank you. Before we hear something else from Matthias, I would like to not forget to say thank you. And first of all, I would like to thank Matthias, my wonderful co-moderator, who's always summed things up quite nicely in between. But of course, as an institution, we'd be nothing without our 42 member organizations and without the very many artists and people who volunteer to help us, and I cannot say how grateful I am to them. We also have strong partners who've been supporting us for many years, the Academy of Arts, many other art organizations, GEMA, FFA, Zen Art Chancellor Berlin, Initiative Music. Initiative Music has helped us develop our new communication concept, and this week a new publication is going to come out, the IU MAC, or the Authors' Rights Initiative magazine. You can interpret the logo any which way you like. So we're very grateful indeed to the Initiative Music that they're so very active. They're using funds from the Federal Commissioner for Cultural and Media Affairs. So the fact that the issue of copyright is so important that you help carry it into the wider public and particularly into the realms of politics, because there's so much they don't understand there. And I'm very happy that we can work together in order to try and make people understand a bit more about these issues there. But now there's a new parliament, and there will be new MPs and new staffers for these MPs. If any of you are watching, listening, we are always happy to answer your questions or to dialogue with you. Another thing, very important, I should have mentioned it first, the team around Phil Knetzer, Till in the camera, Ralph, Patrick, the team of the Academy of Arts. We spent days, 10 of us, to plan and organize the conference. And I'm not even talking about the subject matters, I'm talking about the technical details. It was a huge challenge. We've got a lot of experienced people who helped us, but we all learned a great deal. And I would say we constructive criticism, happy, but after 4 o'clock. Right now, please, only good things, only nice things. Anyway, it was fantastic being with you, with the audience, with the guests. Not just for the sake of it, but because you really are so important, the speakers, and of course our simultaneous interpreters. Every year we have interpreters, they're doing an absolutely tremendous job, because the issue that they're dealing with is, I'm always speechless when I think how they master that. And I think doing simultaneous interpretation is an amazing thing anyway. There are other people who have helped us who don't wish their names mentioned, people who have helped us in weeks and months in preparatory work. And before we say goodbye, 2 more words from you. Well, it's more like 7.5 words, but I promise I'll be finished on time. That's what the agenda says. I have to finish on time. First of all, it's not on your agenda, which you've written to me, but I'll start with a thank you to you, because you are owed a word of gratitude as well. And I'm not saying this just for form's sake, because without you, none of this here would ever exist. And I mean, nobody is aware that we've got a management which is basically you. Andy is just joined to help, and she's at the back. So we've got a management that really does a lot of work. But, you know, they always find a lot of stuff. They go looking for more work and they find more work. And they constantly link things up and manage things. And without them, we'd all be running about like headless chickens. And somebody who's not here today, as many of you have known, Gerd Pfennig, because without him we wouldn't be here at all either. Maybe he's listening, we'd be very happy. He's one of the founders of the Authors' Rights Initiative, and he spent many years until this summer being our spokesperson. He's certainly my mentor, and he's I mean, amazing. I mean, you all had witnessed my, not even talking about my good friend Nina, but I mean, he's been very helpful, very good. And now I'm looking at what we've done today very briefly, because it started, I mean, if we hadn't agreed that I would do a summary and somebody would have done it, I mean, Janine Meyer, for one of her first sentences, appropriate remuneration should be a matter of course. You could say, yeah, well, but sadly that is what we're talking about. There are 2 strains where we can argue for that. One is it's about employee rights. You could say, you know, it's a union matter. That's one path, and we are following that path. But the other one is also quite interesting, and that is the ecosystem idea, the concept, saying that the world in which we create culture, and culture is defined as that part of the world which people create. And that is something which we can conceptualize as an ecosystem. And we should say that this idea of sustainability, which people are rhapsodizing about all the time, why shouldn't we start talking about ecosystems like ours too. I'm a great fan of the idea of open-range authors kept out on the free range and on the ground. So if you buy a CD or vinyl or whatever you do, is this an organically produced CD? I mean, it's like buying an egg, right? We should print a logo on it, right? Open range or something, or organic. But that was something which we've discussed throughout the day. We've always talked about diversity, because without a diversity, there's no ecosystem. We talked about asymmetry, and that ultimately also means the food chain. We discussed the openness of platforms, and actually, we ourselves should also take care that the places where we make our work available to the public are open, are diverse. And of course, by now we have a great many other problems that play a role here. And I've always got an issue with media regulations. All the questions to do with disinformation, manipulation, electoral fraud is something I'm always dealing with. And if you want to get into that, I hope you've got a strong stomach. Then I heard somebody say, hot air doesn't pay. That's another good thing. And we have another idea which is worth thinking about, which was painted in a beautiful picture, the 3X, the triangle, which Oliver Schätzer talked about, with the collective solution and the injunctive relief, which might at least give us a bit of a sword to wield. And ultimately, right at the end, we've got back to where we started. Namely, we said, if we're saying this is a society and it has to work as such, and that's also what the Constitution demands, and we're a society where we're looking after the individual but without questioning the whole, then we also have to insist that we are some of these individuals that need to be taken care of. And especially if society thinks without us, they can't work. And we've heard towards the end somebody saying that innovation is based on creativity. So that means at the end of this event, we've come back to the beginning, and how better to put it. Thank you very much. All I can say now is see you again next year, at the very latest next year. Then we'll ask the new government, certainly. And we'll be celebrating 10 years of the Copyright Conference. And we'll have to drink together. Well, we'll have to toast all of us and each other. Everybody who's listening, thank you very much for that. And you're already invited to next year, but we're doing it also to the people who are sitting in the parliament, which is not far away from here. No, we've invited them. No, it's 15:31. It's over. Well, who else should we thank? Maybe you should thank the weather. I mean, this is appropriate to the conference. We have a wonderful view out of here and great lighting, so it's positive. You see, no new government and the weather is good. Thank you very much indeed.